Okay, well, Nitty Gritty Law School, also known as Sovereign's Paradise, actually doesn't exist, but it makes a good sounding name. We're not formal. Basically just putting on sharing information. I've kind of made a presumption that all of you folks have seen the video or attended a prior seminar. And that's kind of important to the understanding of what's going on here. And of course, if you have any question, feel free to interrupt. Won't throw me off my game. Presumably, I know it well enough to be able to tell you, whatever I have to tell you. But if you do have a question, feel free to interrupt. But basically, we have this. This is the website. 1215.org. All the information you see here on this website is on the actual website on the internet. It's 1215.org. The W's are optional. But we have, it's the law notes, and there's two aspects to the law notes. There's the foundation, which basically gives you all the theory, and then there is the actual example, which is a practical application of the theory. And this was a case that involved somebody going through an intersection and hitting somebody else on a bicycle. So today, though, what we're here for is we're concerned about the case of the People versus Aurora Ticho. And essentially, Aurora was meeting with a car salesman, and it was understood that she was paying with a private check, which implies that it's on a closed account, because an open account is public, closed account is private. She was paying for it with a private check. They, of course, did not really understand that, but it didn't matter, because what they did understand was that she would not take delivery of the product until they received the funds. Okay? That's the key thing right there. So this is not a case of going in and stealing from somebody or writing a bad check to get something. That's not it at all. It's a special kind of check, special procedures. And the procedures have to be followed. If you don't follow the procedures, it's not going to work. So she let them know that. They agreed to that. Unbeknownst to her, they called the cops. And while they were in the middle of their negotiations, and I think she had a check partially written, the cops showed up and arrested her, charged her with 4 different charges. One of them was commercial burglary, which is obviously wrong right on the surface of it. There's no burglary here. So she, when they arrested her, they got bail out of her. She paid bail. She got out. Then she was back in. They revoked bail. It got kind of complicated. Anyway, it was clear that here's a whole chain of people, or I should say persons, who paid no attention to her. She objected to jurisdiction. Case law is absolutely consistent that whenever you challenge jurisdiction, then the accuser and the accuser's court must stop everything and prove the jurisdiction. They cannot assume the jurisdiction. They cannot decide to have jurisdiction just arbitrarily. They must actually prove they have the jurisdiction. Well, that's too bothersome for them, so they didn't do it. They just ignored that. They rolled on. So it got to the point where she did a counterclaim. And in the counterclaim, she told the story. And what they did was she told the story, and she pointed out that she had objected to jurisdiction. They never established jurisdiction, never proved it. and just rolled on. And so that's what the counterclaim was all about. And when you do a counterclaim, the counterclaim must be based on a challenge to their jurisdiction. Okay? When you challenge the jurisdiction, everything's supposed to stop. I mean, it should have stopped anyway, but now we're getting formal. And it was a counterclaim at law based on trespass. Okay? And trespass on the case. Now, trespass is a common law action. And trespass is what you have any time an injury occurs where violence was part of it. False arrest is an injury against your right to freedom, and it involves violence because they physically grabbed her and put her in the jail. So that's trespass. There's also another charge that was made in her counterclaim, and that was trespass on the case. The difference between trespass and trespass on the case is that in trespass on the case, there's no violence. Okay? For example, if somebody cons you out of some money, they convinced you to hand over a pile of money in a paper bag at the bank. Well, there's no violence involved. They simply con you. So that's trespass on the case, sometimes just called case. So that's another common law action. So we, or I should say Aurora, put together a lawsuit based on trespass and trespass on the case. And, of course, the specific issue was challenge to jurisdiction, and the injury, of course, was loss of rights. Well, some of the persons, I should say, that were sued simply did not answer. Okay? Some of the persons demurred. Nobody actually answered the lawsuit. They all demurred. And they all basically sang the same song. They said, yeah, we did it, but we're immune. So there's no conscience on the part of these people. They simply said, we're immune. You can't do anything about it. You can't sue us because we're immune. Well, the case law basically says that they are only immune, they only have immunity, unless there's one of three conditions exists. If a constitutionally protected right is violated, there is no judicial immunity. If they go beyond their jurisdiction, or in other words, they have no jurisdiction. If they have no jurisdiction whatsoever, then they have no immunity. Okay? And finally, if the individual goes beyond whatever his job description is and causes you an injury, there is no immunity. Well, we didn't really throw the book at them. We basically took what was obvious. There was no jurisdiction, so therefore no immunity. And we proceeded on that basis. Now, does everybody here know what a demurrer is? I mean, you've seen them, but you really understand. Okay. Whenever you file a lawsuit, in your lawsuit you say, here are the facts, here's the law, here's the injury, and so on. But it's basically the facts and the law. That's what you put in your lawsuit. Then the person who answers will answer either contradicting the facts or contradicting the law, saying, no, this is the real law, or this is what really happened. And you have your controversy, which then has to be resolved. If it turns out that everybody agrees on the facts, if there's no controversy on the facts, and all you want to do is argue about the law, then the paper that you put in where you're just arguing the law, that's called a demurrer. So whenever you get a demurrer, by the way, don't ever do a demurrer unless you really intend to agree to the facts, okay? Because whenever a demurrer is put into the court, whoever puts it in automatically agrees to all the facts, okay? Pure and simple. So these guys all demurred. The judges demurred. We had 4 judges on the hook. We had, I think, a half dozen public defenders. We had, I think, 5 prosecutors. I think my numbers are right here. And they all demurred. So they all agreed that, as claimed in her lawsuit, that she objected to the jurisdiction and that they ignored it and moved on. They never established jurisdiction. So, guess what? They're liable. Of course, at each stage where they demurred, went into court, had a hearing. She's in jail, so she can't get to the hearing. And the argument is, well, she's made her appearance with her paperwork, which is actually true. So she was there via the paperwork, and they then had a judge sitting on there, and lo and behold, the judge granted the demurs. Well, what we did, we issued a writ of error, vacating the grant of the demur, and then making our own ruling on the demur. And so that's how it progressed through the entire case. Finally, at the end of the case, they basically are dismissing the case, and we're reinstating it. And the case goes on. Real interesting what the very latest, we put in a paper. And it's interesting. Like I said, these guys have no conscience. And they have no respect for their own ignorance. You know, if you don't know what's going on, doesn't it make sense you would find out before you act on it? Okay, well, this is a basic logic that's beyond a lot of people. But here's, I'm going to read straight out of the transcript. This is very short. It's only just one page. But this very last session, there was something went on. And the judge calls the case. And this guy shows up, some attorney, representing the various county defendants. That means, I guess, in this case, the attorneys, I believe it was. It doesn't matter. But here's what the judge says when he starts to speak. The very first thing, after they get their hellos out of the way and who's in the court and who isn't, the judge says, I honestly don't understand how my own court works. I have cases that have been finally resolved by order of this court, and lo and behold, a motion appears. I guess if someone is willing to pay a fee, it will show up on my calendar. Okay? So he admits his ignorance. I mean, he doesn't know. He says, I honestly don't know. Then he goes on and he says, is it her? Yeah, oh, it's a her. Well, under law, he includes her. So anyway, she says, this matter is off calendar. This matter has been finally resolved, and I hope not to see it on my calendar again. You do not have to give notice. The attorney says, thank you, and that's it. It was all over. That was the whole hearing for what it was. Oh, I remember. It was a contempt hearing. Well, anyway, no problem. We'll deal with that. That order's not any good. Let me give a show of hands. How many people here have not attended any of the prior seminars that I've put on? Okay, we got 1, 2, 3, 4, 5. We got 5. And also have not studied the website. Not. Okay. You're handicapped, okay? Because we got some concepts here. I'll try to fill in some of the holes, but there's a lot of stuff here about this that won't quite make sense. It's contrary to your schooling. So, like I said, I'll try to explain it without taking too much time.
What's the video you mentioned referred to?
I've put on seminars, and Dennis here has recorded them. And on the website, it has his address and the price, and he's selling them for a 8-hour session. He's selling them for like $20. So the idea is we wanted to keep the cost really low. I do not get a commission off of it, you know. That way that he can make it even less. and that's how he settled on it, whereas other people might charge $150, $200. As a matter of fact, one of the seminars, one of the CDs that Dennis recorded, I'm sorry, DVDs, right? They're DVDs, 8 hours worth. There's a guy out in Oklahoma who was selling them for $300 a piece. Okay? Needless to say, one of his customers really got upset when he found out he could get it from 20 for Dennis. The guy's argument was that, well, when he sold a DVD, he would help the person answer their questions for free, and it was really collecting in advance for the questions he knew would come. We had a discussion about it, and I suggested to him that he change his business model and that he be up front and just tell him, look, I'm going to charge you for the time it takes to answer it. You know, here's a DVD. So he said, well, he would. I don't know if he changed it or not, but it was interesting that he was able to sell it for $300. So I guess it was worth something to somebody. I didn't think it was worth that much. I didn't think what I had to say was worth that much, but anyway, there it is. All right, so on the Kecho case, basically every step of the way, we had an apparent failure. You look at it and you say, well, okay, the judge rules against us, they ignore us, and so forth. But the thing to understand is that these guys are accustomed to operating fearlessly. I mean, they never have a kickback. And so they think that they're in control. And in fact, they are in control on a practical level in the beginning. I once heard that there's always room at the top. Okay? You've heard that phrase, right? There's always room at the top, you know, top management, whoever's in control, whatever. But the one I heard was, there's always room at the top after the investigation. So this case, at some point, I expect will get investigated. And I've made sure, along with other people who participated here, along with Aurora herself, all of us have made sure that we're building the record, okay? I'll tell you something, Aurora gets a lot of brownie points on this deal. She is a tough little lady, and she is not crumbling under their pressure. She has her highs and lows, that's true. But basically, she's hanging in there, and she understands that you've got to make them break the law. And they're doing it, okay? It's just a matter of time, we believe, when they get caught up with. Our latest thing is that we filed with the court a bench warrant for the arrest of one of the judges. We picked the last judge that had sat on the criminal case. We had served this court and the judges with an order to dismiss the case. So this is from her court to their court. And they instead proceeded, and they brought her in for the proceeding. Now, when they brought her in, they also brought in her court. Okay? So, because they had an order from her court, and they were disobeying that order, and because she was there, her court was there, which meant that they committed this breach directly within view of her court. She could see what they were doing. That meant it was a direct contempt of her court. So we issued, or she issued, an order finding them in direct contempt and fining them $100 each, and basically some other things to be done, reporting them to the various, I think, like, for example, the Council on Judicial Performance, reporting their activities to that. So that's all long-range stuff. That doesn't get her out of jail because they're still riding high on who they think they are. We then, because they were not obeying the order, because they were in contempt, actually twice in contempt with a third one coming down the pike, we then went for a writ of mandate with the appellate court. Now understand, a writ of mandate is not an appeal. okay, even though it goes in the appellate court. But with the writ of mandate, we basically said that, well, think of it this way. Whenever you open up your court and you're borrowing the warehousing services of the court clerk, because she keeps the papers in the warehouse, and we're borrowing the judge, who's supplying them? Well, it's the government supplying it, okay? Well, that government is like an employment agency, and your court is like, let's say, a business. And if you had a business, you'd go to an employment agency and borrow one of their employees on a temporary basis to do a job, and so they pay the salary of the employee that you borrow, okay? Well, the state is kind of like an employment agency. So when we are asking for a writ of mandate, what we're doing is we're going straight to the employment agency and saying, your employee's misbehaving. We don't have the power to fire him, but you do, okay? So that's the concept. So we went to the appellate court and we said, these guys are misbehaving. We found them in contempt twice now so far, and here's what they're doing. And now normally when you go to the appellate court and you have some issue, then it gets assigned to some judge, and then that judge makes his ruling or whatever. That's how it normally works in the statutory system. But we're not in statutory. We are a court of record, and the appellate court is a court of record. So statutes don't apply here. So we went in the appellate court. Guess what? We got an order back dismissing our mandate, writ of mandate, okay? And it was signed by 3 judges. Normally it's signed by 1. Now, why do you think there were 3? Well, the reason is because, first of all, with 3 judges, that carries a lot more weight. In other words, when you get a 3-judge panel, then that makes it pretty secure. But there's one detail that they forgot about, and that is that we never gave them permission to make a decision. Okay? And if you read the actual codes, never mind common law, just look at their codes. The code itself says that the court makes the decision, not the judge. And who's the court? Well, it's Aurora. Aurora and her lawsuit together make the court. They have no authority. So a writ will be coming forward that will vacate that and so forth. Actually, we don't expect real results until we hit the Supreme Court. Because the Supreme Court, these guys, they're concept thinkers. The lower courts, they're procedure thinkers. All they know is procedure, but they don't really understand concept. So we're heading up to the Supreme Court. Thankfully, Aurora's willing to tough it out and has been doing a great job in toughing it out. And she's got the patience and she's willing to wait. She'd like to get out today if she could, you know, and we want her out today. But the reality is that it's extending out, as Ron pointed out, 14 months. Okay? So that's kind of a nutshell. Now, the whole reason for us being here today is to give you a blow-by-blow report of what's going on and an explanation of the strategy. Why did we do what we did? What were the considerations in deciding whatever we decided to do? And hopefully we'll all learn from this. And of course, some of you might see things that I missed and that other people have missed. So this is really, in a sense, although I'm going to be explaining a lot of this stuff, it's entirely possible that you folks have great ideas too. It's a two-way street on this. Well, let's go back to into Aurora's case then.
Can I ask one question?
Yes. Mm-hmm.
When you did the writ of mandate, you filed that with the appellate court. Sure.
Yeah.
When you did the writ of mandate and you filed that with the appellate court, does that surrender jurisdiction to that court?
No, because it's not their court. It's Aurora's court. Aurora owns the court.
She's the one bringing the action.
Yeah. See, what you would have found on the seminars that we had before, that a court is legally defined as the person and the suit of the sovereign. And if you look at California codes, the California Government Code informs the government that the people of this state do not yield their sovereignty to the agencies which serve them. So the people are sovereign. She doesn't yield her sovereignty, so they have no authority to step in where the sovereign treads. And because she's in her sovereign capacity as one of the people of California, she can do what sovereigns do. And what do sovereigns do? Well, one of the things they do is they have their own courts. So her court is her own court, even though she's borrowing the facilities and personnel of the state. Plus, she's one of the people of the state, which means she's one of the owners of the state, which means that their court is her court too. Okay? So, philosophically speaking, though, she's in her sovereign capacity, and the very definition of sovereignty is that the sovereign is not accountable to any higher authority. Okay? So they have absolutely no basis for taking command of her. They have completely screwed up their procedures. They've taken the wrong procedures. The only reason they're able to do what they're doing is because they have the physical power. You know, they have the guns. And us being a peace-loving people, we don't. Okay, Floyd here.
Actually, then, that appellate court was supposed
Mike.
to follow the demand of the sovereign.
All courts are. All the
Yeah.
courts are subject
And
to the
that's what
sovereign.
they had failed to do.
Right.
Okay.
Yes, sir. You had a question.
Yeah, I've got a question. Can one declare himself sovereign, or do you need a common law court of 13 or 5 or 3 or some such to,
Turn the mic on.
approve?
There's a mic.
Is it on? Shoot.
Go ahead. Repeat your question.
Can one declare himself sovereign, or do you need a common law court to approve of your declaration of sovereignty?
Well, first of all, if you're sovereign, you're not accountable to a higher authority. So if you need a higher authority to obtain your sovereignty, then you're hardly sovereign, are you? Okay? So, yes, sovereignty is self-decreed, self-declared. Let's take a brief excursion here, since that is the issue. We go to law notes and the foundation, and then we go over to the question of sovereignty. Here's basically what happened, is at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern but themselves. Okay, so, and the citizens of America are equal as fellow citizens and as joint tenants in the sovereignty. Now, joint tenancy means that we all share the ownership, but each one of us individually is 100% responsible. Okay, that's joint tenancy in property. So, whatever the other person does, you're responsible for your partner, and vice versa. 100%. There's no, I'm only responsible for half. So, the people of this state, as the successors of its former sovereign, are entitled to all the rights which belong to the king by his prerogative. What rights does the king have? Whatever he says it is. No one determines for the sovereign what his rights are. Only the sovereign determines what his rights are. And the legislature recognized this, and they created various codes, and one of the codes they created was called the Government Code. And the Government Code is specifically a set of codes that sends a message to the government employees. The Government Code is written for the government employees. And it says right in there, the people of this state do not yield their sovereignty to the agencies which serve them. Is there anything about that you don't understand? You know, I think it's pretty simply stated. And it's stated a second time in another part of the Government Code. Word for word the same. The people of the state do not yield their sovereignty to the agencies which serve them. First was the Government Code 54950, and the other one was Government Code, well, that was the second one. The other one was Government Code Section 11120.
If I remember right, that was 11120 they repealed. I should have told you that last time. 54950 still stands. So.
Oh, it was repealed?
It was repealed. It's no longer there. I went up on the website.
Oh, really?
Not Find Law, but the other one.
Yeah.
LegInfo. And
LegInfo, yeah.
They repealed it.
Oh, okay. So it is no longer the public policy that the public agencies exist to aid in the conduct of the people's business and the proceedings of public agencies? Okay, well, we'll have to check that out. Thank you. Well, things do change, don't they? But it is still there. I did notice one thing, though. In Section 111.20, the word state is not capitalized, whereas in the other one, it is capitalized. Okay? So what that means, I don't know, but that's all right. It doesn't matter. The reason it doesn't matter is this. Well, of course it does matter, because what is the purpose of a court? The purpose of a court is to put on a good show to convince the rest of the world that the sovereign made the right decision when the decision gets made. So that's the real practical purpose of a court. And so the fact is that you're sovereign and you decree what the law is. And you can make it anything you want. Okay? Anything, absolutely anything. You've all heard of jury nullification, where the jury can suspend the law. Well, that's the reason they have that power. Because the sovereign decrees the law, and you might have a crazy law. And so the power of the jury is to kind of stabilize society and say, well, we don't go with that law. And so they can prevent it. So, but anyway, even though on this new information that Section 111.20 has been repealed or terminated, either way, it's still good law from the standpoint that the sovereign decrees it. And if the sovereign decrees it, it's reinstated. Okay? You decree what the law is when you're in your sovereign capacity. And what I do when I decree the law, in my cases, is I put where I got the wording from. That law exists because the sovereign decrees it, but the wording is copied over from somewhere else. Okay? And that's kind of nice because the attorneys seem to think that you're getting your authority from them. Okay, now we have two questions, one right here. And then...
Wasn't really a question. What I wanted to point out was the difference between the 1850 Constitution and the 1879 Constitution.
Yeah, 1849 and 1879.
Right. That's the...
Is the mic on?
Yeah, it's on.
Is it on now?
Yeah.
Start over.
All right.
Yeah.
Well, the 1849 Constitution is the one that is in effect for us sovereigns.
No, it isn't.
The 1879 Constitution is not
Neither one of them are.
legitimate. That is the corporate Constitution.
That is true, but neither of the constitutions is for us.
Well, right. I mean, if you read I've got the original letter written
Yeah.
by the legislature of California to for people to agree to the Constitution. And in that, it talks about free men and sovereigns. So, I mean, basically, if you want to be under it, you can. If you don't want to be under it, you don't have to be, because we are sovereigns.
That's true.
But I'm just saying the difference on the state, because one's capitalized, the other one isn't. One's corporate state, the other one is the original constitutional state.
Right.
That was
Lowercase is original.
Right.
Right. Capitalized is the corporate state.
And
right.
in anything that they say that they got rid of, it doesn't matter.
Well, see, the thing is the Constitution wasn't written for us anyway. It was written, for, the government.
Right.
Right. So we're not under it. We're over it.
Right. We're over
Okay.
the government, and these
Right.
rules are all for the government, but they try to change the rules into a corporate
Well, of course.
institution,
Of course.
which it doesn't affect us anyway. So.
Well, they want to shut out the sovereignty, I'm
Right.
sure. Okay, behind you.
Bill, what was the purpose or the function when the writ of mandamus was presented to the appellate court? What was she to expect? Why would it be presented there? Did she
Well,
want them
because
to
they're
just-
the employment agency, and we want to get the prestige of that court coming down on them. That does not necessarily mean we let them sign the orders. Okay?
Okay, so should they have just been almost acting like a jury?
They shouldn't have acted at all. They had no jurisdiction to act.
Okay, but why was it submitted there?
First of all, it's Aurora's court.
Right.
See, Aurora has structured her court in parallel with their court, and her appellate court borrows their appellate court judges and borrows their appellate court clerks. Okay?
Okay.
But she's borrowing their image, the prestige of their image. That's why she could have put her court over at McDonald's and done the same thing. Okay? But instead she put the court in their court. Now, but she never gave them permission, those judges, to act. Those judges are all magistrates.
So she should have actually put an order in there for them to be in agreement with, or...
No. She put specifically, we'll get to that toward the end, because all I'm doing is giving the summary overview. We're going to dig into the detail. However, the codes that they operate by specifically say that the appellate court makes the decision, not the judges. Okay? It makes no mention of the judges. In other lower court papers, you'll see it talks about a court or a judge can do something. But in the appellate court, it specifically says a court will do it. Well, that eliminates the judges.
Oh, okay.
Okay? And those judges are all magistrates, and it also says that all the courts are courts of record. The appellate court is a court of record. Again, when you say court of record, that automatically means that no judge is allowed to make any decisions. Okay? Court of record absolutely wipes out the authority that they even imagined they might have had. Okay? No court of record can no judge can make a decision in a court of record. And you can see that if we just briefly go over to there. Here are the requirements of a court of record. All right, it keeps a record of the proceedings. That's number 1. Generally has a seal. That's number 5. It has the power to fine or imprison for contempt. Now, provisions 1 and 4 you will find in Black's Law Dictionary, 5th edition and later. Okay? But it turns out there's 3 more requirements. The 5th one, and then there is the 3rd one, proceeding according to the common law. If you see the court proceeding according to statute, it's not a court of record. Okay? And then it says the 2nd one is the killer provision. It says the tribunal is independent of the magistrate. What's a magistrate? Well, in simple words, the magistrate's anybody on the government payroll that's given some authority. Well, so the magistrates can't make a decision. The tribunal makes the decision. The tribunal is a judge. Well, if it's not one of the those judges that are on, those magistrates, if they can't make a decision, who is it? Well, just use your logic. If you're the king, you're sitting on the throne, and you don't hire anybody to make any decisions in your court, then who does that leave? That leaves you, right. And then if you do hire somebody, you have to give them a job description. Tell them what their job is. Well, by you saying a court of record, you have automatically removed any possible opportunity for them to make a decision. Okay? Because making a decision means you're acting as a tribunal. You can't. The tribunal is independent of the magistrate. And in another part of in the penal code somewhere, it points out that all the judges are magistrates. See if I can find it down here. Here you are. Penal Code Section 808. Now remember, you're not subject to these codes, but they are. They have to respect these things. This is why we bring these in. It says, persons designated as magistrates. The following persons are magistrates. Judges of the Supreme Court, Courts of Appeal, Superior Courts, Municipal Courts, and Justice Court. Everybody's a magistrate. That means nobody can make a decision. Okay? I don't remember who it was. Somebody said that war is much too important to leave to generals. Okay? Well, this is an acknowledgement that law is much too important to leave to the judges. It's the sovereigns that'll make the decision. And the Founding Fathers had a lot more confidence in the sovereigns of the country than they did in the judges of the country. They understood the camaraderie that exists between judges, that it becomes like a club. They understood that principle. And so they created a system here that absolutely allows the people to knock them out of the box, so to speak, legally speaking. Pardon? It's been kept in all these years. Well, yeah, the educational system got changed.
Repeat that, because that's not getting picked up.
Yeah, you said it's been kept hidden all these years. Well, yeah, it has been kept hidden, but the way it was hidden was because it's simply not taught in the schools anymore. It used to be taught, but not anymore. So anyway, sovereignty is where Aurora is coming from. And remember that Aurora is making the claim of sovereignty. Now, that claim of sovereignty does not affect anyone else. Therefore, she's not accusing anybody. Therefore, she does not have to prove it. Okay? Whenever you make an accusation, then the burden is on you to prove your accusation. In her case, she's not accusing anybody, except perhaps herself. So she has no burden of proof. It's quite the opposite. If they think she's not sovereign, the burden is on them to prove she's not. And you know what? They've never offered any such proof. When she challenged jurisdiction, they never said, hey, you're not sovereign because blah, 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 and offered a proof. Never. Okay? Remember the basic rule of every court. If you fail to object, it means you agree. Well, nobody's objected. So that means they agree. And that is the, you might say, the main track of our train here, is that we made the accusations, we listed the facts, we listed the law, they demurred, which means that they agreed to all the facts, and the only discussion is about the law. And guess what? They never challenged the law. They never challenged the decrees that she made. So, you know, they're kind of stuck on here, and I'm sure that there'll be some integrity somewhere. I have not lost faith in the system. If, in fact, we do have a dictatorship, this case will show it. Okay? You know, if we have a dictatorship, I can deal with that too, as long as I know it. But right now, I don't know it. I believe that there are people in government who are honest, who concur with the concept of the Founding Fathers. And if we put in good paperwork, at some point, we'll find that person. And behind the scenes, without us ever knowing who or when or how, suddenly we'll see turnarounds in the judges. They suddenly become so sweet and nice. I don't know if you've ever seen a judge turn around, but when they do, I mean, they're just like bullies, okay? The misbehaving judges are like bullies. You punch a bully in the eye, and suddenly they become the sweetest, wonderful person, you know. I mean, they know how to lap it up, I guess. So I have seen cases where judges did a turnaround. Boy, it was just amazing. You wouldn't think it was the same tiger, you know. Anyhow, all right, so that's the sovereignty thing. So basically, they made their accusations, charges, and so forth. So we did a counterclaim. So this is the very first case here, BC 001. Now, the way I number these things, BC is the first two letters that the court clerk assigned in the case number. So we just gave it uniqueness to distinguish it from the criminal cases as well. Okay? So and then I just number them, because you cannot rely on the dates in the computers. What makes them unreliable is that sometimes you might want to change thing, adjust thing, and the date doesn't really keep it in order. So in order to keep it in order, I've assigned it a sequential number, BC1 and so forth. So we did the counterclaim. Okay, so we'll get into some of the detail here of this case. Now, the counterclaim is different from a countersuit. The California Code of Civil Procedure says that whenever a counterclaim is filed, it shall be treated as a countersuit. Now, that's how it's done if you are within the statutory system, if you're within the Constitution. We're outside the Constitution. So this is a counterclaim, and it's based on jurisdiction. That's the key thing. So they made the original lawsuit in the court, and the court is called the Superior Court of the State of Yeah, Superior Court of the State of California in Orange County, okay? County of Los Angeles. So we filed this case over in the civil division, okay? But the thing to understand, it's the same court. In any county, there's only one court, one Superior Court. Everything else is like, you know how you have one sheriff and everybody else is a deputy sheriff? Well, you only have one court, and all the other courts are just divisions within the court. So it really didn't matter that we filed our counterclaim in a different part of the county and so on, because what we did is we filed this counterclaim and we served the other court with a copy. See? Service. Now, you know, there's a lot of confusion about the difference between service and filing. Okay? So let me just take a moment to explain this. When you file a paper, you are giving that paper to your own clerk. When you serve a paper, you are giving a copy to the enemy. Okay? So when you serve somebody, that's like an order from the court. Whereas when you file a paper, that's a record you're making of what's going on. Okay, so filing and service are two different things. The word file, by the way, F-I-L-E, means wire, W-I-R-E. Okay? Comes from the old days when the clerks had a closet with a wire strung across. They took your papers, put it in the bag, and hung it on the wire. So that's the term file. And so that's what you do. But when you give it to the other person, we don't know what their system was. Okay? You're just serving them. It's an order from your court ordering them to answer. All right, so basically, here's the proper format for a counterclaim. Okay, you have, I'm talking about California. Now, other states have slightly different formats, so this is purely the California way of doing things. But you put the contactee's name in the upper left-hand corner. Usually, typically, that would be the attorney's name. But if you're handling your own case, you put it up there. Phone numbers are optional. They want phone numbers, but the fact of the matter is they are optional. Okay? There's no law requiring you to have a telephone. Or if they do require it, I'm happy to let them pay for it. But the Aurora, she put her return address here. Then you go down to line 8, and you have Superior Court of California, County of Los Angeles, and then you put what's called, this is all called the case caption, this part of it. You have the people of the state of California versus Aurora. Now, the thing is that if you really get technical, if you really do it right, you put the original case, like the criminal case, the people versus Aurora, and then you draw a horizontal line and you put down Aurora versus the people, okay, as counter-defendants. You're the counter-plaintiff and they're the counter-defendants. Whereas in the original case, they were the plaintiff and she was the defendant. So counter means to go the opposite direction. So, and while she was at it, not only did she sue the people of the state of California, she also sued a few extra defendants. And so we have all the judges named that were involved. I want you to notice something. There are no John Does per se. I mean, we have Land Doe down here. We've got Mercedes Doe, Quaker Doe, and so forth. FCU Doe, Complainer Doe. The reason you should understand, it's worthless to put in Does 1 to 50 or something like that. The reason it's worthless is because you're just putting in a fictitious name, but that's not any good. What you have to do is you have to say what the person did. The whole idea of having a John Doe or a Mary Roe is to be able to give a name to a person whose name you don't know, but you know what they did to you. So in your lawsuit, you have to specify that John Doe this, whatever. You say what injuries he caused, and you give him a name because you don't know his name. That's the only purpose of a Doe. You have to make your claim timely. If you're in the statutory system, you have to make your claim timely because there are statutes that limit the amount of time you have to make your claim. And that way you don't have to know the name of the person. You can make your claim. In the case of common law, there are no statute of limitations for one simple reason. There's no statutes. Okay? Statutes don't exist in the common law. The only way a statute can have any standing or validity is for the sovereign to decree it. Now, if you decree it, then the statute exists not by legislative authority, but by the authority of the sovereign. Okay? Okay, well, anyway, we named a whole bunch of people, and that's how the Does fit in here. Okay? And you'll notice that I did not put things like the Honorable so-and-so. Hey, these guys never had an office because they never established jurisdiction. That's our whole position. And we don't recognize titles of nobility. Okay? So they're just human beings, if you will. Okay. Then on the right side, we put the case number that was assigned by the clerk. And we say it's a counterclaim for trespass and trespass on the case, and it's verified. Verified means that you declare under penalty of perjury that the foregoing is true and correct. Or you can affirm it. If you don't declare it, you can affirm it. But the idea is, the whole idea is that you're testifying that this is truth. Okay? And you're willing to get beat up and thrown in jail if you're caught lying. That's really what it's all about. Now, you have to understand this. I know, as Ron had pointed out, that this has its roots in religion. Okay? But the approach that we take here is as if religion didn't exist. We're very secular, down to earth. We point to specific earthly things for whatever our reasoning process is. So if you must have a religious basis or some sort of, I guess, attribute, biblical or whatever, I guess what we could say is that it's religiously, well, how do I want to say this? Well, basically, we don't recognize it. You see, the Bible says something to the effect that Satan owns this world. So the way I divide it up is that there's God's world and there's Satan's world. If it's Satan's world, we call it secular. Okay? That's what it means to me. And I proceed on that basis, and remember the rule, and I lean on this rule heavily. If the person fails to object, it means he agrees. So if I make whatever claim I do, well, then that's what is, if they fail to object. And by the way, they always fail to object, as you will see. All right, so verified means that this really is the truth that we put in here. Now, the truth means the truth as far as facts. You don't have to verify law. You only verify facts. Okay? So, we got our list of them. Now we go down to the actual body of this thing. We have a cause of action, trespass. All right, now, let's see if we can make this a little bigger. There. How's that? So, now, this lawsuit pretty much, I think you'll probably agree, looks like an attorney might have written it. But there is one key set of words that makes it different. And that's right here, right in the beginning, right from the get-go. Okay? Aurora Bautista Quicho, here and after Aurora, is one of the people of California, and in this court of record complains of whatever. Okay? We could say each of the following, just extend it. And then we name all the people that we're unhappy with. Now, that simple little sentence, I guess those of you who have seen the seminar know about this, but that simple little sentence is really disarming. Disarms the opposition. Because typical attorney is going to read this and he says, hey, one of the people in California, what does that mean? You know? Okay, so she's a people. Well, what it means is you're sovereign. By saying you're one of the people of California, you've absolutely established your sovereignty. Okay? And the burden is on them to prove that you're not sovereign. Okay? Now, the second thing is that in this court of record complains of each of the following. And so she's established this is, you see, when you're suing, you can pick your forum. You can go into admiralty, equity, whatever. She chose court of record. Okay? And what is a court of record? Well, we go down to here on the law notes, foundation, and a court of record meets these 5 requirements. An attorney reading these papers, he probably has the latest and best dictionaries, okay? And the latest and best dictionaries leave out items number 2, 3, and 5, okay? So he looks it up and it says, oh, it keeps a record of proceedings. Oh, okay, that makes sense to him. Has the power to fine her in prison for contempt. Sure, they taught him that in law school, okay? That's all they have in the dictionary. So he probably doesn't know. But you got to understand something. I have no sympathy for these guys. Because these guys, if you get one of their business cards, they say they're an attorney at law. At law means common law. Okay? Sure. But what they are is they're all attorneys in equity. Statutes are equity. So they're all practicing by statutes. Not one of them ever practiced real law. Okay, they're not in common law, but they all say they're attorneys at law. Well, I'll tell you what. I'm sure some of you are aware of this idea, if you have a Social Security number, somehow it puts you in jurisdiction as a citizen of the United States and this type of thing, that they do that to you. In other words, the Constitution defines a citizen of the United States as somebody who is either born or naturalized in the country and subject to the jurisdiction. Okay, now if you're one of the people, you're born or naturalized, but you're not subject. Okay, so they don't teach that half of it. They just teach you the requirements of citizenship. Then later on, if an issue comes up, they'll ask you, are you a citizen of the United States? If you say yes, you just told them that you are subject to their jurisdiction. So that's how they do it. Well, you take the title, you get the qualifications. Well, this is exactly how I deal with attorneys. They take the title, attorney at law. I'm going to subject now. I'm going to assume they have the knowledge. They were the ones who bragged about it, you know. So I just hold them to their word. So actually, I don't have to hold them to their word because they're not trying to get out of it. They go in it head first. So if they're going to say they're an attorney at law, that means they know law. And they know common law, because that's what at law means, common law. And we're going to run that court according to common law. It's not my problem if they don't know what they're doing and if they made false claims. If you were going to make a false claim, you deserve what you get, right? So in this court of record complains of each. And this is the only special deal in the entire system. No, there's one other thing. It's where you decree the law, okay? But as you go work through this, you can see there's the defendants and so on. I need to go back up here. I left out an important idea. This is the caption. When we went up to the window to file this, the first time we went to the criminal court, and we had the criminal case number on there. They said, oh, no, we don't handle civil. You got to go over there. Okay? Well, it's all one court. And they should have taken it. But they didn't. Well, who am I to argue? Okay, I don't argue with these people. The best thing to do is, you know, there's an unlimited number of opportunities to do battle here. And these people are awash in ignorance. And as Goethe said, the German philosopher Goethe said, there's nothing so fearful as ignorance in action. So, you know, you have all this ignorance, and it does make it harder. But as it turns out, you can roll with it to some degree. And so when the clerk said, we can't accept that because this is civil, I said, okay, we're civil. Say, point, down the hall or something, or the other building, or the other town, whatever. So I went over there, presented it for filing. Of course, now we don't know what case number we're going to get because it's not the same case. And so the clerk looks at it and says, well, he says, we don't accept counterclaims. Well, he really didn't know what it was. I mean, that's what it boiled down to. All he knew, they got the routine. The Los Angeles court system is the largest court system in the world. Okay? I mean, it isn't just bigger than any court in the United States. It's bigger than any court in the world. And they've got it so divided. I mean, there's a specialist in everything. There's a specialist who takes filings. There's a specialist who takes motions. There's, you name it, they've got a specialist to deal with it. So I realized I was dealing with a specialist who never heard of a counterclaim, probably. So he said he couldn't take that. I said, okay. And he said, and what else, And he looked at it and he says, well, the caption's wrong. We can't have up here the people of the state of California versus Arroyo Quicho. And you need to go take this back, and he says, and change these headings. The rest of the sentence that he did not say was that you need to change these things to meet my understanding. Okay? So here we have all these counterclaimants and counter-defendants. So after he told me all that was wrong with it that he didn't like, I then took the paperwork back, and he was expecting me to go back, fix it and come back. But what I did instead was with my hand and a pen, I scratched out counterclaim.
You left counterclaim on the original bill. You just wrote complaint. Don't forget that.
Oh, I did that?
Counterclaim was on that document.
Oh, okay. I did. Okay, I didn't scratch that out. All right, but we did write complaint on it.
Yeah.
All right. So then over on the other side, put a big X through plaintiff and defendant, that top part up there. So that all got, scratched out. And then down here, I think we changed counterclaimant to plaintiff, and we changed counter-defendants to defendants. And I handed it back to him. I said, how's that? And he said, fine. Okay? Now, why was it that I was able to do it by hand? Well, the reason is if you look in the procedures, the rules of court, California rules of court state that all the papers must be typewritten. Okay? And if you then read further, you find out that typewritten means put on a paper in reproducible ink that is clear and easy to read. So in other words, handwriting is typewriting. Okay? So that's why the clerk was able to accept it. And having been a draftsman in the past, I do print very clearly. So it met his requirements, and he filed it. Now, later on, one of the attorneys in his demurrer, he pointed out that in the caption, they were labeled as plaintiff and defendant, but in the body, we were using counterclaimant and counter-defendant. And he was confused. Okay? He didn't know who was who, what, and so forth. So in our reply, or in our answer to his demurrer, we pointed out, and you should remember this rule, and that is that headings do not control. What controls is the body. That's why I was so willing to go say, okay, you know, scratch out all these headings, all these titles, whatever. None of those control the actual suit. All this caption does is it enables the clerk to file the papers. Okay? So the body is what controls, and it's what you say there that counts. Now you notice it says right here, first cause of action, trespass, and the parties. All that is headings. Okay? Those do not control. The purpose of headings is to kind of help you get a picture of what's going on. But if there's a conflict between what the heading says and what's in the body takes precedence. Okay? The body of the writing. So we named all these people as defendants. And now remember this, that when it becomes cumbersome every time you want to talk about somebody, a party, or whatever. It becomes cumbersome to name all 28 defendants over and over again. So to make a shortcut, you can always give them a nickname. Just like we said right in the beginning that hereinafter Aurora. Okay? That makes it easier reading. Remember, the other person who's reading the paper is a human being. And so that person, you want to make it easy for them to read and understand it. So it's good to pick something that is easy to understand. So we called her Aurora. And then the rest of the paper refers to her either as Aurora Bautista Quicho or as simply Aurora. Either way means the same thing, because what have we done? We set up our own dictionary. The definition of Aurora is Aurora Bautista Quicho. Of course, we also set up a definition for the others. Now, you got 28 defendants. So rather than refer to all 28 names at the same time, refer to them just by one name, okay? And it was hereinafter kidnapper, and all collectively kidnappers. Okay? So you can use, and that's legit. You see, it is wrong to call them kidnappers if you are making a judgment, because the purpose of a complaint is to present to the court your information. So you cannot call them kidnappers. But if you define the word kidnapper as a substitute for all these names, now it's legit to use the word. So throughout this document, we refer to them as kidnappers. Okay? So this is a writing technique that you can very effectively can use, because what are you doing? Remember that in the art of communication, a lot of times the image that you paint is very important. And if you can paint an image without painting an image, that's the ultimate in expressing yourself. And that's what we did. We didn't say they were kidnappers. We just said that's their name. Okay? Yeah, you could. Yeah. Wanted to know, could you call them assholes? I say, sure could. You know. You can have a lot of fun in writing papers sometimes. Use a little creativity. I remember one time, just as a side note, we had an attorney that was really a jerk. Okay, I mean, you couldn't communicate with her or anything, and this guy was trying to communicate, because after all, the rules of court say that whenever you have a motion or something going on, that before you have an actual hearing, the parties should attempt to get together and talk. Okay? It's called a meet and confer requirement. So somewhere there's a rule that's, I don't know why the number 202 sticks in my mind. I could be totally wrong. But anyway, there is a meet and confer rule. And what you do is you're supposed to contact the other party or the other attorney if he has an attorney, and you meet and you confer about it to see what you can accomplish. Now, if you can't accomplish anything, you give a report to the clerk or to the court saying that, well, you tried to meet and confer, but you could not agree because of such and such. And both sides can put in their little report to the court. The whole idea is to try to get this procedure running as smoothly as possible. And really the last thing the judges want to do is sit in judgment. They would much rather the parties settle it earlier if possible. Well, this this person called up the attorney, and he said something, whatever it was. And the attorney, a female attorney, she says, horse shit. And so then he said something else to her, and she said, horse shit. And so then he said something else to her, and she said, that's a bunch of horse shit. So it's obviously they weren't communicating, right? So in the report to the court, we used that term. We quoted her. After all, she's a professional, and, you know, she's probably using professional language. And so, right. And so we wrote this, we organized it. You know, your format is important too. You want it to be easy for a person to read. So we structured it so that the story began at the top of the page and ended at the bottom of the page, okay? And the very last sentence. Now, this was a factual report. That means we're testifying, okay? Now, what is testimony? Testimony means, or facts. What are facts? Facts are anything that affects the five senses. So you have hearing, seeing, smelling, feeling, and tasting. Right. So you testify as to one of those, how one of those. For example, you know, most of the testimony is, what did you see? But that's only one of the senses. We as human beings have the ability to discern voices. If you heard your father or mother speak, would you recognize the voice, even though you didn't see the person? Very likely you would. Okay? And so it's very valid to say, I heard my mother saying something. Even though you didn't see her, she might have been in the next room, but you heard it. And you identified it. You can testify to that. Also, there's a sixth item you can testify to, and that is to your own personal state of mind. You can testify that you were scared, happy, worried, whatever, okay? So, back to this attorney who used professional language, or some technical language that we didn't understand. What we said in our very last sentence was, it is the opinion of the writer of this paper. Okay, he's testifying as to his own state of mind. It is the opinion of the writer of this paper that the attorney was suffering from a severe case of vowel motion. Vowel motion. You know, you have consonants and vowels in the language, English language, right? I'm sure the judge must have enjoyed reading that one. But you know, I don't hold any punches on these papers. If somebody wants to use filthy language, I put it right in the court paper. Hey, it wasn't me that said it. It was him that said it. Okay? Let them destroy their own reputation as their own whatever. If they're graceless, let it show through in the paperwork. You know? You want to... It's okay... Basically what I say is this. It's okay to tell the truth. Okay? And if that person is being obnoxious, just tell it like it is. They can't use decent language, tell it like it is. This is what they said. I'm sure that they hear about that at some point in time. So anyway, I think you got a little too much volume on this. It's ringing. Yeah, you got a little ringing on it. It's just like, yeah, just like there. I think that got it. Yeah, that's better. So anyway, we collectively refer to them as kidnappers, so we can use the language. All right. So each kidnapper exceeded his jurisdiction by either directly, through an agent, or in concert with another, did cause counterclaimant Aurora to be unlawfully and forcibly carried away and imprisoned. Notice this. We didn't say arrested. Okay? Our position is, you see, the minute... you got to be careful how you use words, because if you say she was arrested, well, that's an official function. Okay? You're acknowledging the official function. We never acknowledge the official function. We never acknowledge the jurisdiction. We said she was forcibly carried away and imprisoned. Those are neutral words. Okay? Not arrested. Yeah, as a little side note, words are important. if you ever get involved in a case where a gun is involved, understand, never use the word weapon. Okay? The word weapon, a weapon is an offensive item. Okay? A weapon is used for attacking. An arm is used for defending. We have a right to bear arms, not a right to bear weapons. Okay? Don't ever let them use the word weapon in a case against you, if it ever comes to that. You say, no, it wasn't a weapon. I never had a weapon. Never had a weapon, never saw a weapon. Okay? I had an arm, purely defensive. So it's one of the little technical meanings they don't like us to know. But that's how they do it. The word client. The word client means, let's put it this way. A lot of you have businesses. Do you call your customers patients? You know? You don't have patients. Doctors own the word patient. Okay? So you never call any of your customers patients. Even if you're in alternative health, you don't call them patients. They are called customers. Okay? Why? Because the doctors own the word patient. That is their word, for whatever reason. But they've taken command of that word. The word client means that's a customer of an attorney. The attorneys own the word client just the way the doctors own the word patient. So you do not have clients in your business. When you say that somebody is your client, you are admitting that you are their agent, that you make decisions for them. Okay? That's a whole lot different than having a customer. A customer is somebody to whom you deliver information, product, or something, but they retain full responsibility for the decision to buy it, accept it, and use it. You're not influencing them in the same sense that you would if you were their agent. Okay? So don't ever use the word client, because that makes you their agent. That makes you their attorney. Okay? So, anyhow, here we say each kidnapper exceeded his jurisdiction by either directly through an agent or in concert with another did cause counterclaimant to be unlawfully and forcibly carried away and imprisoned. All right? And we define imprisoned out of the dictionary: to confine a person or restrain his liberty in any way. Black's Law Dictionary, 5th edition. Imprisonment means it may be in a locality used only for the specific occasion, or it may take place without the actual application of any physical agencies of restraint, such as locks or bars, as by verbal compulsion and the display of available force. What does the court do? When they let you out on your own recognizance, or they let you out on bail, don't they have a display of force? Don't they verbally let you know you better do this or else? You got to meet our terms or else? Okay. The reason we put this in here was because Aurora had made bail and she had been released for a while. And then she was back in, I guess, and then she was released. But the idea is that she was constantly imprisoned. Even when she was out on bail, she was imprisoned. That was the point we were trying to make. Because she's claiming in this lawsuit $50,000 for each day that she's imprisoned. Okay? Okay. So she's imprisoned against her will, without jurisdiction or good cause. The word good cause, the phrase good cause, is a technical meaning. Good cause means a legal reason. Okay? Good cause does not mean, well, we have a moral justification. Not that at all. Whenever you see good cause anywhere in the legal world, that means a legal reason, specific. Okay. At the onset of the unlawful imprisonment, counterclaimant Aurora was duly engaged in good faith in a negotiation and purchase of a chose, and exercising her substantive right to contract with another at arm's length. Now that sentence is loaded with legalities. Okay? We identify that it was from the beginning, at the onset of the unlawful imprisonment, counterclaimant was duly engaged. The word duly means that it meets the requirements of both the common law and the statutory law. So she was doing what was right. negotiating. That's, you have an unlimited power to contract. And so she was negotiating. And if we look at footnote number 2, duly, according to law in both form and substance. Equity deals with form, common law deals with substance. Okay? So, and we said it was in good faith. Okay, that's important. Had no hidden agenda. Okay? Being upfront with the other person. And trusting the other person to be upfront with her. And she was purchasing a chose. A chose is a thing. In this case, it was an automobile. Okay? And chose, by the way, is a word that's used in common law. That's why we used it. And exercising her substantive right. A substantive right is a common law right. Everybody heard of the Miranda decision, the Read Your Rights decision. That decision says specifically that where substantive rights are concerned, there shall be no rulemaking that will abrogate them. I think that's the actual wording. Okay? In other words, substantive rights are common law rights. Now you notice I avoided saying common law because I know that all these attorneys, all these judges, they're all trained to go against the grain, against the common law. It's a policy. They don't want anything to do with the common law because, frankly, the common law is the law of the people, whereas the statutory law is the law of the special interests. So, you remember the purpose of a court, the number one purpose of a court, above everything, is that it's a stage upon which you put a good show to convince the rest of the world that you're right. Okay? Let's go back here. In our fundamentals, we look at court. And here it is. Okay? A court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. So, keep that in mind. Okay? Now, is that coming out big enough to be read on the screen?
Yeah, I zoom in a little bit. It's small.
Okay. Well, let's see. Let me terminate this, and we'll go to a different browser. That'll give me a little better control for you. Now, this is the word processor here. Take a moment for it to come up. But anyway, a substantive right. Here we go. Here we go.
Do you recommend that?
Oh yeah, it's a great program. I personally prefer what is it? Not Mozilla. Mozilla ahead of Internet Explorer, but it's called. If I can find it. I guess I don't have it on here. Firefox. I prefer Firefox. That's a great program because it has a lot of protections built into it that Internet Explorer does not have. Okay, well anyway, here we are, and we'll go to, okay, this is it. Law Notes, Foundation, and we're court right here. Okay, and let's go 150%. There, how's that? Okay, you want it bigger? Because I can make it bigger.
All right, if it'll fit on the screen.
That's a whole white, that's a whole screen.
No, no, it doesn't.
Makes
Okay.
new columns. I mean, makes new.
Yeah, it just
Yeah.
it reformats. Mhm.
Make it big as you can. I mean, not as big as you can,
Look, we aim to please.
but one more sentence. Yeah.
Is that what you wanted? Okay, be slow reading, however. Okay, but a court is a stage upon which the sovereign conducts his show so as to satisfy the rest of the world that his decision is a good one. This is very important. You're trying to impress. You see, you depend on these people. As much as we find ourselves in contention with them sometimes, the fact is we're depending on them. So, and there are honest people in there. I really believe that. Sometimes they're hard to find, but they're in there. And so if you give them good paperwork, then you give them the tools with which they can argue your case behind the scenes. So this particular webpage goes into the details as to why a court is a stage. But it's important, at this point we won't go into it, but it's important for you to understand it is a stage. You want people to have a clear picture as to why you're right and they're wrong. Why do you outrank the judge? Whenever we put in any orders, we always put in a complete explanation. I mean, we've put in a half dozen orders at least in this case, and in every single one we explain it as if we had never explained it before as to why it is that we're right. No one can ever pick up a paper out of this case and say that we are presumptive or assumptive. Okay? When they pick up the paper, they get the whole explanation with it, which makes it a little tough for them to argue then. Okay, so we're back to foundation here. That's it. All right. Okay. The kidnappers, without good cause, interrupted the negotiations, then imprisoned counterclaimant Aurora. During imprisonment, the kidnappers took further casual, ill-considered actions to further imprison counterclaimant Aurora for up to 3 years without trial or due process. Now, the reason we're saying this is because what they did is they shoved her over into Patton for mental evaluation, and the court order actually said that she could be detained there for up to 3 years. Okay? How's that for imprisonment without trial? Right. Well, that was before Homeland Security. That's an SOP for California. And by the way, just as a little side note, if you look up these codes that authorize the such imprisonments for evaluative purposes, it's interesting to notice that there is one group of persons in California that is 100% exempt. In fact, not only are they exempt, but there's an actual prohibition on doing any mental evaluations, and that group is the judges. Okay? They know the power of this to destroy, and they're not about to do it, subject themselves. So there's they have a...
Was that legislative?
I believe it is. Yeah, it's the legislation for, there's the Council on Judicial Performance, and the Council on Judicial Performance can order a review of the record of the judge. They can order a specific medical evaluation. Okay? They cannot go on fishing trips. If there's some specific issue, they can order that the doctor go to a professional and have just that one thing evaluated. But in any case, they are absolutely prohibited from ordering a judge to get a psychological evaluation. So it's okay if he's crazy. Okay? Okay.
Is that discriminatory?
Absolutely. In fact, I think you have a very strong argument relating to titles of nobility. That you want to know if say again. Oh, if that's discriminatory. Of course it's discriminatory. That's exactly what a title of nobility is discrimination. So here the judges have a title of nobility where they are exempt from whatever is applied to everyone else. So anyhow, I plan to, at some point, to use that in the papers. We're saving that one. Okay, from the moment she was taken away till the present, Aurora under color of law. Color of law is a technical term. There is law, and then there is color of law. Okay? Law is the real thing. Color of law is a pretense. Okay? It's just like I remember one time, this is before I really got involved in this stuff, but one time a cop stopped me. And I did not have adequate registration on the car. So he decided to, but anyway, so he gave me a ticket, right? And then he noticed that about 100 yards down the street, there was a construction going on. And because there was construction on, according to the code, he was authorized to remove the car that might be blocking the construction. Well, of course, it's 100 yards away. That's the length of a football field, all right? And so what's he doing? He's using color of law, the pretense of law, in order to, because he's taking some vindictive action, okay? So he took the car and left me walking, okay? All right, well, this is called color of law, and it is unlawful for, under federal law, for anyone under color of law to deprive another person of any right, privilege, or benefit even, okay? So if I'd have known that at the time, I probably would have made a good issue of that. But, and by the way, there's no statute of limitations. I probably still could. Somehow I managed to keep busy with other issues. Okay, but anyway, whoops. There we go. Okay, so let's see. I need to redo this. Here it is. Text width. All right. Yeah, let's got to change the game plan here. Now let's go to text width again. Okay. So okay, from the moment she was taken away till the present, Aurora, under color of law, was kept in actual or constructive imprisonment. The word constructive means that you're able to construct your conclusion out of the facts at hand. So we construct from all the orders that were issued, from things that were said, that she was actually imprisoned, okay, constructively. You have similar things like, for example, let's say you're living in an apartment and the landlord does not fix the roof. And so the place is really not habitable because water's leaking in or whatever else. You have been constructively evicted from the process or from the premises. So constructive is a powerful word because you can say, well, no, he didn't say I was evicted, but you can tell I was evicted. There was no place for me to live. What I was actually in a place not suitable for human habitability. So constructive is a powerful word. Constructive notice, as distinguished from actual notice. From the facts, you should have had notice of something, whatever it is. Okay? So, let's see, got a kitty here. Okay. Although she objected to the assumed jurisdiction, those who kept her imprisoned under color of law did not respond to any of her demands and requests for proofs of jurisdiction or for reinstatement of her liberty. Now, that's a factual statement. She objected. They did not respond. Now, later on, they demurred, which means they agree. This is all true. Okay? You see the power of that? Okay, so we're setting them up, basically. They continued to assume the jurisdiction without proof of jurisdiction or any attempted proof of jurisdiction. Now, when we say they assume the jurisdiction without proof of jurisdiction, those are all statements of conclusion. So they really don't count as facts. But what does count as a fact is that they made no attempt at proof. There was no action on their part. She was denied counsel of her choice. She was forced to accept counsel not of her choice against her wishes. Counterclaimant Aurora continues to be subject, under color of law, to the assumed jurisdiction, will, and control of the kidnappers. Okay? Under color of law, Aurora was twice subjected to pseudo-psychological evaluation. The word pseudo means false, phony. Okay, not the real thing. The first pseudo-psychological evaluation failed to satisfy her kidnappers. The second pseudo-psychological evaluation resulted in a Star Chamber court-ordered incarceration of up to 3 years without any trial, without the concurrence of the uninvited court, with the concurrence of the uninvited court-imposed counsel, and without opportunity for counterclaimant to object. They shut her down. Okay? They told her directly that she could not speak. She had counsel now. Okay? Okay, so that is the overview of this whole lawsuit. And that's good. Remember, as a technique, as a conversational technique, you tell people what you're going to tell them, then you tell them, and then you tell them what you told them. Okay, as they said. So the telling them what you're going to tell them and the telling them what you told them, those are basically summaries. But then you have, in the middle, you have the detail. So we just went through the summary. And in fact, we label it here, introduction. Okay? In fact, yeah, we identify the parties, and then we have the introduction. And then we get into specifics. Each counter-defendant acted in such a way or failed to act in such a way. Now, you understand that if you look at Title 42, Section 1983, isn't that the one that basically says that that you have an obligation to act to prevent harm? Okay, so this is where we're heading with this, because it's entirely possible that this case is going to end up in federal court. Okay, because once we exhaust the state procedures and we show that there is absolutely no protective process, then we go to the federal courts. Yes?
I was just get the mic. Hold it. Yeah.
Mike, where's the microphone?
At what point do you determine that you've exhausted state remedy?
Well, you can go through the state remedies, you know, the procedures. When you run out of procedures, you know, when the Supreme Court says no, you've run out. They're the highest, you know, procedural authority in the state. So there is no more opportunity to argue. But you don't necessarily have to wait till then. Sometimes it just simply becomes blatant. These people are, you want to speak and they don't let you speak. Or right here we probably ran out because, well, we still have the, you know, the appellate procedures and that sort of thing, which we're not using because we claim we're right all along. So we're kicking it upstairs but on a different foundation. Instead of appealing it, what we're doing is we're saying, we need the power of the court. Decision's already made. See? Yeah.
When you take it to the federal court, do you go as a habeas corpus, or would you take it as some other action?
That's a strategy decision. You know, you kind of have to size up the enemy and figure, well, which is more on your side. In this case, I would tend to want to do a lawsuit because I want to basically get a piece of their hide. See, in habeas corpus, there's nothing punitive in a habeas corpus. There's nothing compensatory in a habeas corpus. You basically all habeas corpus is a determination of status, you know, and then whatever orders issue, those orders are based on that status. But in a lawsuit, because a habeas corpus is not actually a lawsuit, in a real lawsuit, you have a plaintiff and you have a defendant and you have injuries, and you want to get paid for those injuries, compensated for your losses.
Can you file both?
Sure.
A lawsuit
Yes,
and
they're
a habeas at
independent.
the same time?
They're independent of each other. Yeah, you can do either one. And habeas corpus is unique in that you can file it any time before, during, or after judgment. So it's never too soon.
Oh, no. Hers was premature.
Well, there was one, that's okay. There was one point in here where they said that her habeas corpus, when she did put one in, they said it was premature, excepting they didn't know how to spell. They said permature. But in any case, yeah, they said it was premature, but it's never premature for habeas corpus. The whole question is jurisdiction. If they have no jurisdiction, you shouldn't be subject to it. Okay? So, all right, so each counter-defendant acted to deprive counterclaimant Aurora of her liberty, or each counter-defendant failed to act to prevent the loss by counterclaimant Aurora of her liberty. Further, each counter-defendant is a willing participant in concert with each of the remaining counter-defendants. So this is the setup for conspiracy. Okay? So you don't have to use the word conspiracy for it to be conspiracy. We just said, hey, he's a willing participant in concert with each of the others. And that is a fact, and they never denied it. In their demur, they admitted it. I think this will look good if we get into the federal courts. What does the IRS do? IRS sends out a notice. You fail to respond, right? And they send out other notices or whatever, but you don't use the right technique. Because you did not properly object, it means you agree. By the time you end up in court, all they do is they say, well, look, you did this, 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 this. You never really objected, so the court has no choice but to convict. Okay? Well, we're doing the same thing to them. We're just saying, here's the things that happen. If they don't object, must be true. And we're going to hold them to it, too. Okay. At all times, let's see. At all times mentioned in this action, each counter-defendant is the agent of the other, and in doing the acts alleged in this action, each is acting within the course and scope of said agency. The following paragraphs describe what the kidnappers, under color of law, either acted or failed to act as obligated. Each defendant exceeded his jurisdiction under color of law. Each counter-defendant acted in concert with the remaining counter-defendants to effect the unlawful loss of liberty of counter-claimant Aurora. Notice we never use the word arrest. In my opinion, there's no such thing as a false arrest. An arrest is an arrest. That's an official function. Might be wrong, but it's definitely a real arrest. Okay? So that's why I avoid the word arrest. On or about June 29, 2004, Landau, an agent of Land Rover. I want to tell you something. We had no knowledge of how this arrest came about. We were largely guessing. Okay? So that's, you have to understand that. What? Sure. Time to swap tapes here. Okay, understand that in this case, we really didn't know how she came about to be arrested. Obviously, somebody called the cops, okay? But we don't know how or when or what. Well, later on in their papers, we found out what happened. They admitted what happened. What happened was that she had gone to a company, a car dealership, and had purchased a car using the same technique. The process was never completed, okay, but it was in process. They had gone a certain length, you know. Then she went to this other car company, and she was doing the same thing, buying a couple of cars for her friends. Well, it turned out that it was the same company, but a different name. They had their company, and then they had two DBAs. They had two doing businesses as. And so with the two separate companies, well, when the paperwork came through, they recognized the name, and so the first company was the moving force. It was the force that resulted in the second company calling the cops and bringing him in. But you see, it was the same question. They didn't follow the procedure. Okay? And because they didn't follow the procedure, the check appeared to be no good. But it was a private check. If you don't follow procedure, it's not going to work. Well, it was good. Well, I suggest that if somebody is going to hold these people to the game plan, what they should do is type up a little instruction sheet saying specifically, here's what you do, and hand it to them. Because otherwise, when you talk to people, whatever you say is words to the wind. They blow away, and how do you prove you said what you said? So you really should have a printed instruction sheet. You say, look, here's the steps you have to go through to make this work. Yes?
What kind of check is this? Repeat that.
Yeah, basically the whole concept of redemption. Yes.
The closed checks are... Use the mic, please, for the tape, please.
The closed checks are good because of what they did with the trading with the Enemies Act and so forth when they went off the gold standard. Those checks have to be routed to the Treasury first, and the Treasury has to release the funds. It's a process, and they should have had instructions. Perhaps they overlooked that, but those checks have to be honored by the Treasury because of the bankruptcy.
Same as the bill of exchange, right?
That's right.
Repeat that. You said that's right, too.
Okay, he said it's the same as a bill of exchange. Yes, it is. It is the same as a bill of exchange.
Right.
And they have to put that in deposit and release the funds once it goes through once it reaches the proper parties at the Treasury.
Well, of course, what's happening is this whole approach is viewed as an attack on the banks by the banks. Okay. So they're basically, they don't want this thing to get out of control, because if they do, that whole phony thing will collapse. They'll have to go back to real money, heaven forbid. Yes.
What they're really afraid of...
Go ahead. Give them the mic.
What they're really afraid of is the debt will disappear and these bastards will be out of business.
That's exactly what they're for.
Yeah, that's basically what we just said. Right.
When you write those checks... When you write those private checks, there's no debt behind it. It cancels debt. They don't want that because the friggin' Pope can't survive.
Did she make a mistake while trying to do that, or did they just...
Well, I think the mistake was not giving them the printed instructions. That's just my own personal opinion, because had she given them the printed instructions, the next question would be, well, did you follow the instructions? If they say no, no case. That's it, see? Well, anyway, that's an afterthought. Right now, we're dealing with the before thought. So she agreed to buy the automobiles, but informed Landau that she would not take actual possession of the automobiles until the paper transactions were completed. All paperwork and funding of the transaction would be completed before she would accept the automobiles from Landau or Land Rover South Bay. The reason for not taking possession of the property is that the full payment would be in the form of a private check rather than a public bank check. In parenthesis, a private check requires special private banking procedures. No actual transfer of possession would or may take place until said procedures are completed. Failure to follow said procedures voids the transaction in its entirety. Okay, it's our agreement, right. And in their demurs, they admitted that's all true. Okay. Landau and Aurora commenced to fill out the paperwork. Before completing all the paperwork and the contract negotiation, the Redondo Beach Police Department officers appeared. On information and belief, now see, whenever you're making up an affidavit, which is what this is, it isn't just a complaint, it's a verified complaint, or in other words, it's an affidavit, also known as a declaration. So whenever you make it up, sometimes you have to guess at the information. Sometimes you really don't know. So in order to cover it, what you say is that on information and belief. That's a very commonly used phrase. You say on information and belief. That way, you're putting it in with the facts, but you're really just testifying as to your own state of mind. You have information, you have a certain belief. That's fair game to testify to. We got the microphone?
Couldn't you also put in there that the counterclaimant reserves the right to amend any part or portion of that?
No.
Okay.
No. That's another thing. I see that a lot where they want to reserve the right to amend and so forth. Don't do that. Because basically, when you put in a reservation like that, then you're not making full testimony. Okay? You're not testimony. Okay? So I wouldn't do that. Besides, if you do get new information, you can always amend it. There's no reason to waffle on that. Yeah.
Well, a lot of times they block you from getting the record. That's why I use that in mind, because they block you from getting the official records, and you have to sue out to get those records a lot of times.
Sure. Okay. Anyhow, on information and belief, counterclaimant Aurora alleges that Lando, Land Rover South Bay, or someone acting with their knowledge and approval summoned the Redondo Beach Police Department police officers. Okay. Now, we have on the police report, we found out that the arresting officer had badge 1168 and his name was Johnson. Now, that's all the information we had about him. So, this is a form of John Doe. We don't know who he is, but we have enough identifying information that we were able to label him as 1168 Johnson. Okay, so that's what we did. Remember, you don't have to know the names of the other parties. All you have to do is describe what they did and put a label on them. We could have called him kidnapper number 1. That would have been fine. But we chose to call him 1168 Johnson because that is exactly what was on the official report that they had at the police department. Okay? Under color of law, 1168 Johnson assumed the jurisdiction and unlawfully and forcibly carried counterclaimant Aurora away and imprisoned against her will without thorough investigation. I guess should have said imprisoned her against her will, without good cause and for reasons that to this date are still unknown to her. Okay? Now, here's another technique. Look, you don't have to know why they did something. Habeas corpus, if you do a habeas corpus, one of the things that the rules say is that you need to say why it is that you're incarcerated. And then the rules continue on. It says, if known. Okay? So don't fall into the trap of playing the part of their attorney. Okay? As far as I'm concerned, they need to explain themselves. I don't have to explain them why they do things. In fact, I'm not qualified to explain why they do things. So that's what we said right here, that she was imprisoned against her will without thorough investigation, without good cause, and for reasons that to this date are still unknown to her. And understand, they admitted in their demurrer that they did not conduct a thorough investigation. See how this case is building up? Now, when I say they admitted it, I'm not saying that they actually wrote on that point. But the very definition of a demurrer is that you agree to all the facts, you're only arguing the law. So every factual thing that I read here, they admitted to when they filed the demurrer, even if they didn't talk about it. Okay? Matter of fact, let's just take a little quick sidestep here. Let's see. I don't think I can, now that I think of it. But I can get close to it. On the demurrers,
Bill?
Yeah.
Is it possible to get some of these briefs on a disc?
Well, ultimately, what we're going to do is put them all on the website. Yeah. But, yeah, very near term. We're at a stage now where I think we can gather it up. There's a lot of stuff that has to be scanned in, you know, that is not scanned in, this type of thing. So what you're seeing here, this list is all papers that we wrote. Okay? You won't see many of the papers that they wrote, just our response. But, okay, so for the judges, okay, opposition to demur. The judges wrote their demur, and it was real interesting what they said in their demur, and we quoted them. Okay, as soon as it comes up here. Okay. Now let's go down here. Okay. No, that's not it. Sorry for the delay here. I'm trying to find this thing here. Well, I don't see it here. We'll probably come across it. Basically, I was just going to show you what the judges did in their demur was they pointed out that the demur represents an agreement to the facts. They provided the case law themselves. So they're admitting, we're saying they did nothing to prove their jurisdiction. They admitted it. Now they want immunity in spite of that. But in their own papers they admitted it. So anyway, I didn't find it, but that's basically what happened. So, all right. So now, when the complaint was filed, now the way criminal process starts up is that anybody, can go up to a judge and swear to the fact that this act was done and this law was violated, that there's a crime committed, okay? Anybody can do that. Normally, the prosecutor does it. And in fact, if somebody who's not a prosecutor does it, there will be a lot of resistance on the part of the judge to give you the acknowledgement you should have. But anybody can go up to a judge and let him know that a crime was committed, and then he can order that it be investigated and prosecuted. So what happened was that somebody, we don't know who yet, eventually we'll find out, but somebody appeared before the judge and made out an affidavit saying that these crimes had occurred and needed to be prosecuted. The thing is that we couldn't read the signature on the verified complaint. And it was not typewritten, and nobody in the prosecutor's office would tell us who that was, even though they knew who it was. So what do? Well, what we could do is sue and go through discovery and all that. We didn't do that because, frankly, that takes effort, and we're lazy. Okay? Not really lazy, but, you know, it's an unreasonable amount of effort. So what we did is we gave him a name. We said Complainer Doe did this. Complainer Doe is a person who signed Exhibit D, felony complaint. Under color of law, Complainer Doe assumed jurisdiction to continue the imprisonment of counterclaimant Aurora. Counterclaimant Aurora is informed and believes that Complainer Doe is either suing as a persona named People of the State of California or is suing in the name of another whose name is People of the State of California. You see, the complaint was People versus Aurora, right? Now, our philosophy is this. We claim they never had jurisdiction. So it was not the people against Aurora. It wasn't the state against Aurora. What we had was a bunch of loose cannons out here who, under color of law, are pretending. So this is a personal lawsuit from beginning to end. The state is not involved. Okay? So what we did is we said, here's some person. We don't know who he is. But we've assigned him the name Complainer Doe. And Complainer Doe has another name. He also calls himself the people of the state of California. That's his other name. So we never admitted that the state was a party to the action. We identified him right here that we're informed and believe, okay, that Complainer Doe is either suing as a persona named people of the state of California, that's his other name, or he's suing in the name of someone else. Now, under law, you cannot sue in the name of the other. Okay? If I see somebody beat you up, I cannot sue the offender and try to get compensation for your injuries. You have to sue yourself, okay, in your own name. So you can't sue in the name of another. So whatever this person is doing, we don't know if it's his real name, people of the state of California, or if he's suing in the name of someone else. And either way, he's disqualified. Okay? So this is just a personal lawsuit against some other personal person. Okay? All right, Exhibit D contains various accusations against counterclaimant Aurora. Counterclaimant Aurora is informed and believes that each of the counter defendants, especially Land Rover, Landos, Federal Credit Union, we just named all the people we thought were connected here, is acting in concert with Complainer Doe. In the alternative, each of the counter defendants is an adverse, unwilling counterclaimant. Okay. In the alternative, each of the counter defendants is an adverse, unwilling co-counterclaimant who should have an interest as a result of being involuntarily included in Exhibit D under color of law as a named victim. Now, you see, there are times in a lawsuit, there are times when you've been injured and someone else is being injured, and that someone else, now you cannot sue in that other person's name, okay, if he has been injured. But what you can do, you can say, this person is important to my case. This person has an interest in the outcome of this case. And this person should be right by my side suing with me, but he's not. And because he's not right by my side suing with me, I'm naming him as a defendant, specifically an unwilling co-plaintiff. Okay? And so you can drag someone in kicking and screaming in this case, and he's got to justify himself because remember this, you named him as a defendant. And if he doesn't play ball with you, he becomes liable. Okay? Because what's going on? If he should be in there fighting the battle and he doesn't, he's just making it harder for you. He's aiding the enemy, isn't he? So you can, in a lawsuit, include an unwilling co-plaintiff. You see that person and he should be right there by your side with his sword drawn just right along with you. And he's not. Name him as a defendant. An unwilling co-plaintiff. Yes?
What about if it's a case of, let's say, a spouse that has been injured and scared to go after the damaged party?
Well, are you injured?
Are you? Absolutely.
Okay, then if you're injured, yes, you can bring your spouse in.
Okay.
I'm not sure that's the best solution to a marriage, however. Sometimes these theories don't work. But yeah, you can bring anybody who shares in this responsibility, who shares in the injury, and should be with you. If they're not with you, they're against you. I mean, that's pretty simple. So I just wanted you to be aware of that technique. I hope you guys are learning something out of this. Hope you're getting what you came for. Okay? All right. So we name him as an unwilling co-plaintiff. Said adverse unwilling co-plaintiff, or co-counterclaimants, are Land Rover, South Bay, Lando, Federal Credit Union, FCU, Doe, Mercedes-Benz, and so forth. You know how these people have been injured? Very simple. They could have sold a car. Okay? We don't know. The whole reason for this court process is that we're going to sort this out. We really had partial information. We weren't really sure who was who, what's what. We knew she was negotiating with a Land Rover. We knew that cops don't just show up out of nowhere. So either they called, or somebody in concert with them called, or somebody's interfering with the contract, interfering with the deal. So whatever it is, it attacks the interests or involves the interests of Land Rover. So we include them. On Exhibit D, Amy Hannah Broersma provided the signature which authorized complainer Doe to proceed. If you look on the form, it's true that there was a complainer, but that's just to make it official, all right? But he does have a job, and he has to keep the boss happy. So in every organization, they have controls. And so this paper got the approval of the supervisor. Okay, so we sued the supervisor. That's basically what it amounts to. So Amy Hannah Broersma got named as the supervisor because she provided the authorizing signature that, because the complainer could not move forward with it. You know, that was part of apparently his job definition. He had to get the boss's approval. Amy Hannah Broersma could have stopped complainer Doe at that point, but apparently acted in concert with complainer Doe to continue the imprisonment of counterclaimant Aurora. So that's how we made the boss responsible. On Exhibit D, Grady Miles is named as the Redondo Beach Police Department I.O. That, now what would that be? That's information. That was the information officer, right?
Investigating officer.
Oh, investigating officer, right. And, okay. And apparently is acting in concert with complainer Doe to continue the imprisonment of counterclaimant Aurora, who is informed and believes that Grady Miles is acting for that purpose. Okay? By the way, Grady Miles defaulted.
Right. So did complainer Doe.
So did complainer Doe. Let me finish talking about complainer Doe. Complainer Doe, what we did was when we served the papers at the district attorney's office, we knew he had to work there, right? Had to be a district attorney that was doing the complaining. Well, the person who was apparently in charge of the office, the person who was receiving all the service for all of these DAs we did name, this person would not, she admitted she knew who he was, but would not say who she was or who he was, okay? So she's hiding information from us. So basically we said, well, here you are. He's served. You're responsible. And that is a legitimate service technique. Now she has that responsibility to deliver that paperwork to the right person. Ultimately, if that person does not respond, if that person defaults, because they were properly served, the one who failed to turn the paper over now becomes responsible, and the person that defaulted now has a cause of action against that individual. So we can collect from him and through him collect from the person who failed to deliver the paperwork. On the other hand, we also suspect that the person who took the paperwork was the one who signed the complaint. And that was why it was throwing up such a strong barrier. Again, we don't know. But we have the bases covered. By the way, complainer Doe defaulted. Okay? It's okay with us. We don't mind defaults. Okay? Anyway, on or about July 1st, 2004, counterclaimant Aurora was involuntarily brought before a court not of record, and also not a Nisi Prius court. Oh, well, let's go up here. on 16. The California 1879 Constitution defines all California courts to be courts of record. And here's the actual quote out of that Constitution. Now, by the way, one of you brought up the point that you have the 1849 and the 1879 Constitutions. It doesn't matter. Neither Constitution applies to us, okay? But the Constitutions do apply to them. The current scam is that the 1879 Constitution is the Constitution. Well, guess what? You can hold them to that, okay? And if it works to your favor, all the better. Well, look what the Constitution says. I'll bring this up to the top. Okay? It says, Article 6, Judicial, Section 1. The judicial power of this state is vested in the Supreme Court, Courts of Appeal, Superior Courts, and Municipal Courts, all of which are courts of record. Cool. What's a court of record? Well, one of the things is the proceeding according to the common law, isn't it? Okay? All the judges are magistrates. They're not allowed to make any decisions. Cool. So you see, so what we're saying here is that we're bringing this to the forefront. Now, you see, let me explain the arraignment process. You see, all the courts are courts of record. That means proceeding against the common law. When you're in a court of record, they cannot say, Joe Blow, you are accused of violating Penal Code section so-and-so. Why? Because in a court of record, which is common law, there's no statutes. There's no codes. Okay? So they cannot make an accusation like that against you. So what they do is they get you in front of the court and they say that you have violated penal codes, or you're accused of violating Penal Code section so-and-so. How do you plead? And they inform you of the three choices: guilty, not guilty, or no contest. Okay? Well, in each case, when you plead guilty or not guilty or no contest, what are you doing? You're saying, yes, I violated it, no, I didn't violate it, or I'll let you decide whether or not I violated it. But in all three cases, you're agreeing to the validity of the law, of the statute. Well, there's a fourth choice that you can make, which is, I don't agree to it. That's not even the issue. I'm not going to let you break out of the common law mold and go into special rules. Okay? So they're kind of stuck. The whole purpose of arraignment is to get you contracted into agreeing to working according to those rules. If you don't agree, they got a problem.
They do that by getting you to stand under the charges.
They get you to, he says they get you to do that by getting you to stand on the charges.
Stand under, understand.
To understand the charges. Do you understand? Do you stand under the charges? Yeah, that's right. They do that. Do you understand? No, I don't stand under them.
Do you? The judge?
Yeah, right. Well, the judge does. He has an obligation to obey those rules, but you don't. Okay? So you can, and you'll notice that there is nothing in the Constitution, as far as I can tell, that authorizes statutory courts. They're all courts of record. Okay? And that's what we're holding them to. Now, if they're not a court of record, if they're not proceeding according to the court of record, then that makes them what's called a special court. And let's jump to that, because that's a very important concept. And believe it or not, Nisi Prius Court is a court that you get into because you failed to object. She was objecting. So they did not have a legitimate Nisi Prius Court. Okay, let's see. We got to go to. Let's go to the. Contempt here, I think, is where we're at. Let's see. Okay, mandamus motion, that should cover it. Okay. So we go down here. I think we got, oh, that's the actual motion. We gotta have the, okay, this is it. Okay, check out these footnotes right here. I think it's 3 and 4. Okay, no, 4 it has to do with the Constitution. Now this is really important. Stick around for this one, just for a moment if you would. Okay, because this is really important. You all know that the state of California calls their courts superior courts. Okay? But I want you to understand something. That's only a name. It doesn't have any meaning. A true superior court is a court of record. Okay? If it's not a superior court, if it's not a court of record, then it's operating according to statute. Those statutes constitute special rules. In other words, the jurisdiction is granted by these rules, it's defined by these rules, and they run according to those rules, and they make charges or whatever they do is all in accordance to these special rules. Because they are special rules, it is an inferior court. The superior court, the true superior court, encompasses the whole world. It is unlimited jurisdiction. The special rules define the special court, which is operating according to those rules, and it cannot vary. In other words, the criminal court cannot judge a civil matter. The civil court cannot judge a criminal matter because they're limited in jurisdiction by their rules. Neither one, the criminal court cannot take into account civil issues and vice versa. It's only a court of record that can take everything into account. So this court of record is a superior court. The inferior court, or the court going according to the special rules, that's an inferior court. Now, the difference between the two, both courts really seem about the same in how they operate. But the difference is this, is the inferior court, whatever it does, whatever decisions it makes, whatever procedures it follows, they are not presumed to be valid. Now, they're also not presumed to be invalid. But the point is they don't carry this presumption of validity. A common law court takes everything into account. It has access to all the information, all the philosophies, everything. Therefore, its decisions are presumed to be valid. Now, what's the difference between presuming valid and presuming not to be valid? The difference is this. In a superior court, if you want to challenge the decision of a superior court, you have to take the record and go to an even higher court, the appellate court, in order to get things fixed. Compare that to an inferior court. In an inferior court, the decisions are not presumed to be valid. They are subjected to what's called collateral attack. In other words, attack from the side. In other words, you can sue the inferior court in a superior court. A fresh new lawsuit. That court is wrong because they screwed up. Whatever you want to say, whatever is the case, they came to a bad decision. And you're suing that court in order to fix that decision, and you're doing it in another court, namely the court of record. So that's the difference between the two. You can fix an inferior court by suing it in a superior court, but the only way you can fix a superior court decision is by appeal. And then they have to go by what the record says. And the only way that the appellate court can fix a lower court's decision is if the record shows that it was acting in inferior capacity anyway. Okay? So here's the actual case law. It says right here, Note 5, inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. That was ex parte Kearney, 55 Cal 212, and Smith versus Andrews, 6 Cal 652. Also, it says here, note 6, the only inherent difference ordinarily recognized between superior and inferior courts is that there is a presumption in favor of the validity of the judgments of the superior court and none in favor of those of the inferior court, and that a superior court may be shown not to have had power to render a particular judgment by reference to its record. That's ex parte Kearney, 55 Cal 212. Note, however, that in California, superior court is the name of a particular court. But when a court acts by virtue of a special statute conferring jurisdiction in a certain class of cases, it is a court of inferior or limited jurisdiction for the time being, no matter what its ordinary status may be. And that's Heidenfeld versus Superior Court. It's Heidenfeldt versus Superior Court, 117 Cal 348. Also 49 Pacific 210. And Cohen, Cohen versus Barrett, Barrett, Cal, 5 Cal 195 and 7 Cal Juror 579. Oh, all of those cases were taken out of Volume 7 of California Jurisprudence, page 579. So that's really an important thing. So I want you to know, here's a couple of interesting things. If any of you have ever been beaten up by an inferior court, you can go to a court of record, common law court, and sue them for that decision. Okay? And because it's a common law court, there's no statute of limitations. There's no statutes in a common law court. So if you've got a burning issue, remember this. The common law court actually is very close to reality. Are you still feeling the pain? If you're still feeling the pain, then you must still have a cause of action. Okay? That's how the common law court works. Okay? So those are not dead issues, all these cases. Okay, if you want to escape now, I'll let you escape. You're on your way out.
The only thing I was going to bring up was...
Take the mic.
Go ahead, T. Yeah.
What you covered was that last case that I'd read about, that any court that is that is using a statute as
Sure.
its foundation for bringing a case against you is an inferior court.
Right.
Period.
That's exactly right. It's an inferior court, not a superior court.
Do you know of any common law courts that are set up here in California?
Yeah, this one.
You said you have to set it up yourself.
It's yourself. You set it up. Let's go back to the beginning of the lawsuit. Okay? Paragraph 1. First 2 lines. Right there. I am Aurora Bautista Quicho. No, that's not it. Where is it? Oh, this is the wrong. It's the other one. Okay. Yeah, here we go. Paragraph 1. Okay?
In the case of LA County where they've merged both and there's no
Put the
longer
mic on.
superior.
Mic's not on. Your mic is not.
What about the case in LA County where they've merged the 2 courts to eliminate the inferior court?
No. That's their game. Okay, we're talking about our game.
Yeah, I know, but I'm
Okay?
in LA County.
No. Well, what about it? There's nothing about it. They don't rate.
Still inferior.
They're inferior. Okay? Look, here's what we do. Aurora filed her case. She identified her sovereignty, and she identified the forum. Aurora Bautista Quicho, hereinafter Aurora, is one of the people of California. That's the sovereignty. And in this court of record complains of each of the following. That's how you set it up.
You just turned it into the inferior court into a common law.
Yep. That's right.
Repeat that in the mic.
Yeah, he said that she just turned it into a common law court. Well, it never was any court, okay? It didn't get to be a court until she declared it as such. Okay? Okay.
Bill?
Yes.
Now, that's the problem you're having now, right, as you're going through the process now.
Well, our
is
problem...
they're not recognizing it your court of record and sovereignty.
Well, our problem is that they're lawless.
Absolutely.
Okay? It doesn't mean we're wrong.
Oh, I didn't say you were wrong.
Yeah, I know you didn't. But that's the point I'm bringing out, is that it doesn't mean we're wrong. They are being lawless. We've got them up against the wall. That's why they're doing this stuff, is because they cannot do it lawfully, so they're going to do it unlawfully.
And it's only going to get worse. It's not going to get better.
Well, that's what we hope.
Makes them more liable.
Makes them more liable. Well, that's true, because it's accumulating at $50,000 per day, each day that she's in. We're up to, like, what, $20 million or so now? Okay, more than that, I think.
I want to make another comment here. You've all heard of plea bargains. I'm going to tell you the purpose of the plea bargain. Number one, there are no attorneys when you're into a plea bargain, ever. And the only reason for a plea bargain is so that when you accept the plea, you justify all of the things that they've done to you, and you would kill this case. So, when they offer a plea bargain, I don't care if it's for a traffic ticket. It's they want you to justify what they just did unlawfully to you. No other purpose. The plea bargain is not to help you, it's to justify their illegal activities.
Mm-hmm. That's basically it. Okay. So, let's see, back to this. Okay, so I wanted to make you aware of the difference between an inferior court and a superior court. Your superior court is always a court of record. An inferior court is not a court of record, not proceeding according to the common law. Okay, so we're back to this. So, all the courts are courts of record. Okay, we got that covered. But of course, it has to act like a court of record to be a court of record. Otherwise, it automatically converts over into an inferior court if it does not conform to the requirements of a court of record. And here we are. It's, okay. On July 1st, 2004, counterclaimant Aurora was involuntarily brought before a court not of record and also not a nisi prius court. Okay, a nisi prius court is a court that exists because you did not object. Now remember, if you do not object, it means you agree. So we're saying here it's not a court of record and it's not a nisi prius court. Exhibit E contains a true and correct copy of the official record of a said court. Thomas R. Sokolov acted as a tribunal and magistrate. Paulette Pacchioni acted as a district attorney. Counterclaimant Aurora objected to the jurisdiction of the court and the appointment of John P. Torelli as her public defender. Counter-defendants Sokolov, Pacchioni, and Torelli, without proof of jurisdiction, each ignored Aurora's objections and proceeded under color of law to continue her imprisonment. At no time has counterclaimant Aurora ever entered a voluntary plea. Okay, because they're entering a plea for her. Now, as a little side note, if you're ever in front of a judge and you're not pleading, you're objecting to the jurisdiction, and he says, all right, he says, I'll enter a plea for you. Okay? Now, the codes, I think the rules of court specifically say if you don't enter a plea that he can enter a plea for you. But that's, I believe, if you're just passive. Yeah.
Only in a felony.
Only in a felony, they say. Okay, that's, I didn't see that when I read the rule. But if it's restricted to felonies, that he can do this. But here's an interesting tack that I know has been tried from time to time, sometimes successful, sometimes not. But what the person did was he objected to the plea being entered and challenged the judge and said, are you acting as my attorney? The judge says no. Then he says, well, then you've made a judicial determination. Thank you for determining that I'm not guilty.
Like that.
Just a thought.
Aren't you supposed to ask him if he's making a judicial decision or?
That's what we just did. Aren't you supposed to ask him if he's making a judicial decision? That was your question.
I
And
did that. I did that in court.
you did that in
It
court?
didn't quite work.
Well,
It just
hold
started
on.
with-
Hold on. You said it didn't quite
I
work.
also messed up at the
Put on the mic.
You also messed up in what?
Yeah,
Hang on.
yes. Should I start over?
Yeah, put the mic on.
Yeah.
You can read
Turn it
right
on.
from the transcript right here.
Turn it on.
It is on.
Well, then speak.
Luke?
Well, see, the thing is, what you're saying is that, okay, you tried that. Now, you have to go the next step, okay?
Yes.
Look, the next step is this. That was not your court, okay? You were in their court. You now pinned them down on a judicial determination, okay? Now, they're going to do and say whatever they're going to do and say because they have the power, all right? So, but you've got them cornered in that sense. The next step is to sue them. They are an inferior court. Yours is a superior court. One of the factual considerations that your superior court would make is that he had made a judicial determination. And then your judgment overrides his judgment. Okay?
Basically, we did win the case in the end, but what they did after he boxed the judge in, the judge then said he was issuing a bench warrant against him, which he never issued because we looked in the court of record afterwards. Put him in jail for 24 days to try to get him to plea, and he would not plead.
Right. And that's all suable
Okay.
time.
So we eventually won it, but he was incarcerated.
Sure. That's now suable time.
Yeah, and that's why we're here, to learn how to get the
Yeah,
rights.
well, okay, but you didn't attend the seminars, did you?
Right.
And you haven't watched the tapes or the videotape. Okay, so you don't have the clue on that yet.
Right.
But you will. Okay? Because Dennis has these DVDs.
I explained it to him.
Yeah.
Where I messed up was when I asked him if he was making a judicial decision and all that, he said no. And he asked me if I would like him to drop or take away his decision. I did not know what to do at that point.
Right.
That was past what I had studied. What I should have done was said, yes, I would like you to get rid of that decision if you're not going to make it, if it's not judicial.
Yeah, well, I wouldn't have
Then
given
it
him
would have
that
been at
leeway.
a standstill.
See, what you should have done,
Well, then
what
we
you,
would have been at a standstill.
no,
Otherwise,
what
I
you,
accepted his.
what you should have done is not ask him if he's making a judicial decision, but to thank him for it. Okay?
That's another tactic.
Yeah, because when you give him a choice, he's liable to take it. He'll make a choice. So you don't want to give him a choice. So you give him a choice. Well, you do give him a choice on remember this. Never, ever ask a question unless you know in advance what the answer will be. Okay? So in this case, you ask him the question because you know the answer. You ask him, are you acting as my attorney? So you know what he's going to answer on that one, right? So it's okay to ask that. And if he says no, then you say, thank you for your judicial determination, because that's the only thing that's left. It had to be a judicial determination if he wasn't acting as your attorney. Okay? And then, once you've got that, now he either obeys his own decision or else he is proceeding against you from that point on under color of law, falsity, and now you have a basis for suing him in your own court of record.
We can't bias and prejudice.
Well, he's simply wrong. No bias or prejudice, just flat out wrong. Okay.
Is it important to say on and for the record that think you've made a determination?
Well, let's also cover that point. First of all, you're in an inferior court. Okay. The thing to understand about an inferior court is that it has no record. A record does not exist in the inferior court. It's true that they made notes. It's true they have a docket sheet. It's true that they said, okay, this was the issue of the decision. All of that looks like a record. But a court of record owns the word record the same way the word patient is owned by a physician. Okay? Only a court of record has a record. A court not of record has no record, even though they're keeping notes, a history. Okay? So that's really an important point. Sometimes we refer to the record. You can say for the record, but the fact of the matter is there is no official record in the same sense that a court of record has a record. Now, what is a record? In a court of record only has two things in it. Anything else is just note-taking, but is not part of the record, even though we talk as if it were. A court of record, all it does is it keeps two items. First, it makes a record of the proposal to the court. What is it that you're asking the court to decide? The second thing is the decision that was made. That's it. That is the record. Everything else is not part of the record, even though it's mixed in.
This is what he said. He said,
he's wrong.
As he was talking to Roy, he goes, this is all being recorded, by the way, so it's there for posterity if we need a record of what was actually ruled.
Yeah, well, he's wrong. See, only a court of record has a record. Okay?
And it's for posterity because he actually testified against Roy in court.
Well, okay, it's for posterity, but that's not a record. Okay? The word record is owned by a court of record and no other court. Okay? Court of record, the word record is owned by a court of record, and no other court owns that word. And it is acknowledged that they use the word record in the equity courts, but it is not strictly correct. Okay.
Well, we actually asked him if this was a court of record.
Where's your microphone anyway?
We actually asked the judge, is this a court of record? And he said, yes, it was.
Yes, that's fine.
Did I just make it a court of record?
No, because you did not make it a court of record. You see, what happened was that he said yes. Now, that's true. He said that. But the fact is, it's not a court of record because why? Are they using statutes or common law?
Statutes.
Well, then they don't qualify.
Right.
They can say they're a court of record all they want, but that doesn't make them so.
And they don't proceed according to common law.
That's right. All right, let's go back to... You have a very powerful voice, by the way. You have a very powerful voice. Yeah, I don't know if you're aware of it. You really come through strong, even when you're whispering. Okay, but let's look at back to court of record. All right. Here are the 5 requirements for a court of record. Now, the 5th one's optional. Okay. So the 4th one, the first 4 are absolute. If the court does not meet this definition, then it is not a court of record. It doesn't matter what the judge says. Okay? Is it time for a break? All right, let's take a break. 10 minutes?
Yep.
Okay, it is now officially, according to this computer, 12:23. So we should start at 12:33.
And Bill has absolutely no sympathy for us smokers, I can guarantee you that. Okay, we're here today for the Aurora Quicho case, and the importance of this case. As soon as Bill was making me capable of comprehending something about the common law, which he'd been trying to do for a long time, I became full force and aware of its importance as this case got started and developed. And as I had mentioned just a short time ago about how the plea bargain is not for any so-called defendant's purpose, it's for their justifying their incarceration of everybody. To tell you how brave and how strong this little lady is. She was offered about 4 months ago, and this offer's come down more than once, but they offered to give her disturbing the peace, no probation, no fines, blah, 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 on and on. Walk out the door today, lady. Keep your nose clean for 3 years, and we'll totally destroy this whole case. Now, here's the lady at that point in time had been down for almost a year. But the one thing that she understood was once she said, I'm guilty of jaywalking, she has now vindicated all of the crime and corruption that has been done against her. So she told him to take a flying leap at a rolling donut and has opted to stay into the can, not for her own benefit, it's for your benefit. If, I'd mentioned this probably one of Bill's early seminars here, that if there's any salvation, if we're able to salvage the common law, that will be as near to Resurrection Day as you're ever going to get. Because that's the foundation of our country, is sovereignty. As I mentioned this morning about the 3 goons that came to visit her in the jail.
Mention it again, because we didn't tape it.
Well, they indicated to her, now you got to remember, these are 3 goons. They're probably all from the fictional world of Oz. In other words, they've got some kind of card that says, I'm Judge so-and-so, I'm psychiatrist so-and-so, or whatever. We have no idea who these goons were. But they indicated to her that she was a minority citizen. Now, how does a fiction piece of toilet paper, not worthy to wipe my ass with, tell a live person that you're lower than me? They're the scum of the earth. I love Sharon Martin's depiction. You're a kiss-my-ass public servant. So, yeah, stay in your place. Well, anyway, this meeting today should be standing room only. When and if this case is settled, and hopefully it's going to be to the benefit of all of us that Aurora is putting her neck on the line for, willing to stay there under these confined conditions, because she would like to have the America that she has studied. Now, wouldn't it be interesting if these gutless bastards would put into writing that when you are a minority that comes here from another country and you want to study about America, stay out of the Constitution, don't proceed to the common law, and never, ever touch a court of record, and never, ever try to stand up for yourself as a sovereign. You're a piece of crap. Well, I want the lousy bastards to put all that in writing. Is that where their jurisdiction comes from? As Sokoloff, the first magistrate inferior court bastard, said to her, lady, I have, because she challenged jurisdiction. But of course we have in their rules, in their statutes, in their codes, in their laws, when jurisdiction is challenged, everything drops and you go and prove your case. Sokoloff said, I have jurisdiction over whether you like it or not, lady. Then the second approach to jurisdiction said, you're a minority citizen. All of these are pieces of crap. Fictions. Kiss-my-ass public servants that hate the people of the state of California, that hate the people who try to attach to the Constitution of the United States, we the people of the United States, in order to form a more perfect union. Yeah. Every free-thinking individual in this country should be in this room today, getting acquainted with what we happen to have, just an absolute powerful dynamite lady trying to salvage this. But her mistake was her choice of investigating her adopted country. I want the bastards to put it in writing. That's all that I'm looking forward to. Where'd Thornton take off?
He said be back in just a minute.
And by the way, this morning I did point out that the Green Book, if Rick would just hold it up there, that's called The Plot Against Christianity. It's an introduction to the Talmud. Half of the book explains the Talmud's procedure, written by Elizabeth Dilling, a Christian lady some years back. The other half of the book has the exhibits from the Talmud itself that she was extracting and whatnot. So without trying to get into that full volume, Forever Books, if you could ever gain an understanding of the Talmud from that short introduction there, it would give you a leg up on Christianity and Jesus and some of the other things that are going on. That's why the bar is the bar between you and Christianity. That's why it's the religion of old. That's why they've written a song for the Christians that Christians just love to sing. Give me that old-time religion. And I tell people, you've got it in spades. These were the people that crucified Christ. And when crucifixion became unpopular, they went to the Inquisition. And when they couldn't torture nearly enough people, they turned it over to what they called the secular system. The secular system is the poli system. And in this regard, it's the police. Once the police finds out he's nothing but an inquisitor for the Pope, maybe he'll back out of his position and take on a decent job or something here in this country. In the meantime, I want to give this back to the fellow that's dedicated his life to understanding this American way of life. And by the way, this also, this common law will do away with the necessity for attorneys. They won't have to attorney anything for you. And today we don't have attorneys or lawyers. We have plea bargainers, and it's their job to save the government's ass from their illegal arrest. Okay.
Thank you.
Okay, Bill, you're on.
By the way, what Ron did not tell you was that for years he's been a supporter of this. He's kind of earned his position to be up here and talk. For many years he had what was called the Comedy Club. That was our nickname for it. And he paid the rent, he had the copy machines, he had a library, and anybody who was involved in some issue could go to his place for no cost and use all the facilities and everything. And he did that for several years. Yeah, I got an entanglement here. I don't understand why that would happen. So, but anyway, there we go. I think we're there now. So anyway, so I guess how many are here? 24? Is that the count, the official count here? I guess Ted will do an official count because I got to deal with management, make sure they get paid. But anyhow, I want to kind of give you an outline of how this whole thing is. So I brought this little easel here. But basically, what we did, there was the criminal complaint, okay? That's what started it. I don't know, can you all see that? Yeah, I guess you see that, right? All right. That's supposed to be an M. Yeah. Put a couple, whatever. Anyway, that was the criminal complaint. That's what started it all. So what we did is our next step, we did what was called a counterclaim. Well, we turn the tables on them, and we become the plaintiff. Now, you have to be a sovereign. You have to be a plaintiff. Otherwise, you don't have anything. Okay? They are the attackers. They're the plaintiff, and you're the defendant. The plaintiff is the sovereign, and the defendant is the subject of the sovereign. So, but they are false sovereigns because they're operating under limited authority. So the counterclaim, you, in your sovereign capacity, are one of the people, so you rise up above them in terms of authority. So what we did, we sued them. We had 28 defendants, okay? And the way it broke down was we had, basically, we had judges, we had prosecutors, we had public defenders. No, we didn't get those guys. Okay? Public defenders. I think there were 4 judges, 5 prosecutors, and 6 public defenders, something like that. We had some banks, and we had the car companies. Okay? Pardon? And we had a couple of doctors in there who were part of the prosecution team. I think that pretty well covers it. Cops, we had the cops in there. So basically, the banks pretty well got away because at the time we filed the lawsuit, we didn't know who was who or what was what. We didn't have the information we needed. We didn't really have good access to Aurora to nail down this information. And after we found out the information, we chose not to do anything about it for one simple reason. We were on a track. We made our commitment to sue whoever was suing. And if we could have changed it, okay, there's nothing that would have stopped us if we chose to. We could have changed it and put these. But the problem is that when you change it, you delay it, okay? And we had enough. That's an important thing when you're doing a lawsuit is to know when you've got enough. There's no point in suing for $20 million when you've got $10 million already. What's the difference? If you're either going to collect both of them or collect none of them. So we just had enough. We had the important players in the game. We had the judges. We had the car companies. And the prosecutors were not that important to us. The public defenders weren't that important to us. But the car companies, those were the deep pockets. Okay, a couple of big companies, and the judges were they were merit and so forth. The cops were minor players, and the doctors were minor players. Yes.
How do you determine exactly what kind of damages you're going to go after, let's say, for false imprisonment and stuff like that?
Well, basically, it's what's right in your heart. If you think you made a profit, it's too much. If you were left hungry, you didn't sue for enough. But in your heart, you know the answer. We settled on $50,000 a day. We said, look, that seemed like fairly typical of a lawsuit when somebody, in the regular system. in the statutory system, 50,000 days seems to work out. I know a lot of people quote that case that was 1.26 million per day or something like that. But the problem with that case is that the guy was in only for 20 minutes. He was given 20 minutes of jail time, and then people are extending that out. Well, if it's this much for 20 minutes, how much would it be for 24 hours? It doesn't work that way. You got to remember that in a good lawsuit, you have to look reasonable to the rest of the world. Nobody's going to pay any attention to you if you got over $1 million a day. Believe me, they're just not going to. You're just not real. Okay, 50,000 a day, that makes sense to a lot of people, and that seemed to be what. So that's. I mean, it was a little bit arbitrary as to how we picked the number, but we picked it. She's been in long enough. It's over $20 million now. You know, whether we collect it, I don't know. But the thing is that this was kind of the list of defendants. Now, on these defendants, basically, all the judges were lumped together. They had one attorney representing them. All the prosecutors and the prosecutors and the public defenders, they were all represented by one attorney. Would you believe one of the public defenders did not even know we had sued her? We served her address. It got assigned to a defendant attorney to defend her interests, and she never was informed. I mean, that really upset her when she found out, because she showed up in court, and one of our people on our team informed her of it, and she said, "What?" She didn't know. And I think, did she disappear from the case after that? I don't know. Who was it? Who was it that informed her? Were you the one that told her?
Hey, Bill?
No. Somebody told her, yeah.
Yeah. I don't exactly remember how she found out, but what she did was she walked into the courtroom on a day that Aurora was supposed to be there, and she went up to the judge's desk and took the file. And she went back and read it, and that was in April, by the way. The suit was filed November the 5th, 2004, and whoever her attorney was never informed her that she was being sued. She didn't find out until April.
Yeah.
And so then she went down to talk to Aurora about it, and lo and behold, then she, got herself out of the case. Mm-hmm. Out of the criminal justice system judges over there, only one has recused herself, a female judge, by the way, and some of them haven't been called back for a second shot. Are you listening?
No, he's counting.
Oh, okay. Anyway, the long and short of it was that the hearing that was supposed to be called that day, and I forget who was there with me. I think Ted was there with me that day. Seeing as how she hadn't returned and it was getting lunchtime, the judge set the hearing for the following Monday or something to that effect. And then about the time they were breaking for lunch, in come this attorney that had taken the file and wanted to have it reopened again. And the judge said, "No, I've already made my decision. It's going to be next Monday." Well, lo and behold, her witnesses, whom they hate, we went ahead and left because nothing was going to happen until the following Monday. But they brought her in at 4 o'clock and ran another kangaroo court star chamber proceeding on her. Anyway, it's just been a real madhouse with this case.
Well, okay, so anyway, she didn't know she was being sued, so that was a surprise to me, because by what authority does any attorney represent anyone without their knowledge? Well, the judges, these guys demurred. Okay. The prosecutors demurred. Public defenders demurred. The banks never answered. We served them, and I guess we did default them, but the fact is it was flaky. So we'll probably never really push the point against the banks at this point. Unless, if we do, we're going to have to clean it up a little. because they were never really properly served. We didn't even really know if it was the right bank, okay? And we just haven't pursued that direction because we already have our targets, okay? Namely, the judges, prosecutors, public defenders, and the car companies. Those are the important players in the game. The doctor, he was there, but and he demurred, okay? One of the cops demurred, and another cop defaulted. So we had plenty of admissions, plenty of opportunity, and then when they demurred, we answered the demur, okay? And then after we answered the demur, there was the hearing. The judge verbally awarded their demur, granted it to them. But before they had a chance to write it up, we filed in our written ruling. And it wouldn't have mattered if it was before or after, but we were more on top of things than they were. So we filed the written ruling on their demur. Then eventually they followed through and filed theirs, and then we issued a writ of error vacating the judge's ruling, even though he signed it. So all that's basically the sequence that happened. But that's kind of the big picture of where we stand. And then finally, after we had the rulings on the demur, and the writs of error correcting the bad rulings of the judges, then what we did was we issued a judgment. We put the judgment in, okay? Now, there's been some criticism on how we handled the judgment. You see, when we put the judgment in, we filed it with the court clerk. The court clerk accepted it, stamped it. We have our receipt, a conformed copy. Now, conformed, when you have a conformed copy, what that means is, which one you looking at here? Which line you on? Up or down?
I'm going to write it down. Keep going.
All right. So when we filed when you conform a paper, what that means is that you go up to the clerk, you give her the file copy, she stamps it and files it. Then you give her your copy, she stamps it and gives it back to you. That stamp is your proof that you filed it. Okay? That's your receipt. You can get several copies conformed. Typically, they'll conform up to maybe 3 or 4 copies. So you want to be sure you get a receipt because that may be important later on. So we filed the judgment. The judgment disappeared, never showed up on the docket. Okay? Well, I can tell you where it went. It went on the judge's desk. Okay? Now, that's illegal. It should have gone filed in. But the judge got it on his desk, and he hasn't done anything with it. Now, at this point, here's where the criticism comes in. Some people are saying we should push this and get it onto the docket. I say, no, we shouldn't push it. Because as things stand right now, we filed it, we got our receipt. That is a good judgment. Docket sheet doesn't mean anything. It's what you got in your hand. We have a judgment in hand. So now we're using that judgment to do other things with it, okay? If we were to push the point, the judge may suddenly wake up and issue an order canceling the judgment, having it removed. If he were to do that, we can correct it with a writ of error canceling his cancellation, okay? But why go through the fight? I'd rather do our damage first and then fight that battle. For example, one of the things we did under California Code of Civil Procedure, there's a section in there. Now, anybody ever heard of a lis pendens on property?
Yes, sir.
Yes.
Okay. Lis pendens, what you do is you basically put a claim against the property. You're saying that that property has got an obligation on it. It is California policy, at least the last time I heard, where only an attorney can do a lis pendens. Okay? If you're not an attorney, the county recorder will not accept the lis pendens. However, sounds like what? Well, in a sense, yes. But here's the thing. He says it sounds like fraud. Okay, now, in a sense, that's right. But here's what it really is, I think. You have two systems. You have the statutory system, and you have the common law system. The statutory system, the Attorney General issues opinions all the time about what he thinks the statutes mean. He could be right. He could be wrong. But that's what he thinks it means. So he has issued an opinion to all the county recorders that a lis pendens only has to be accepted from an attorney and not from an individual. But you see, the statutory law is based on the common law. They model it after that. And that means if you see something in a statute, that means there may be something in the common law that functions essentially the same way. Okay, well, it turned out there is. So there's another provision in the Code of Civil Procedure called preservation of interest. And anybody can make up a preservation of interest. And you take that and you record it with the county recorder. So the preservation of interest basically says that the title is clouded, that there's a question as to who's really going to own this property in the future. There's some sort of battle going on, and you are giving a notice that you are preserving your interest in the property. So if anybody comes along and buys that property later, they are presumed to have had notice if you record it with the county recorder, and it works just like a lis pendens. And all these people, these reporting agencies, we really screwed up the sale of a property one time by putting on a lis pendens, because we had this lawsuit going, and the subject of the lawsuit, believe it or not, was the property itself anyway. So we were right on target with this preservation of interest. We put that in. That person went out. He thought he was really cool. He went out to get a loan to capitalize himself to do something, and he ran into this wall. They wouldn't make the loan because the preservation of interest was on record. Okay? So that's your protection. It's Code of Civil Procedure, I forget, something like 880 or 800, somewhere in there. But you can look up preservation of interest. So the common law angle, or at least the statutory mechanism that fulfilled the common law technique there, is called a preservation of interest. And anybody can file it. You don't have to be an attorney, and it works as well as a lis pendens. Okay? So that's what we did. Yeah.
The last time I was over at the county recorder, they refused to file anything for me, saying that unless I could show them a mandate of law that required them to file it.
What was it that you were filing? It wasn't a preservation of interest, was it?
It was an affidavit.
Right. Yeah, that's a whole different game, see. But if you do a preservation of interest, which, by the way, is an affidavit, then they will take it. We've never had a problem with it. Because it mandates right in there. That is the mandate. It tells them right in the code that they have to file it. It even gives you the form. That's actually written in the law, the form that you use. How you lay it out.
Thank you.
Yeah. So, anyway, so what we've done, we filed in that judgment, and the very first thing we did after we had the judgment in is we put a preservation of interest on all 4 judges' properties, their personal properties. Okay?
Got a question,
yeah.
Bill. Preservation of interest, do you need to have, or should you have, a cause of action already filed with the court of record in order to file a preservation of interest?
Well, that's what a preservation of interest means, is that you have an interest in the property. You have some legitimate, it could be any reason. It could be that you're a dentist and you did work on his teeth and he owes you for it. And so now you want his property as payment. But the best one is to sue him, and you have, and in this case, we even went to judgment. We said, we have a judgment on against this guy. And that's why we're interested in his property.
So if you have a promissory note,
Sure.
then you file a preservation of interest
Sure.
on the property, even though
Right.
you haven't gone to any court of record to
That's
enforce
right.
the promissory note.
Yeah, you see, the promissory note, you have an interest in his money because he owes you, right? And if he owns property, you have an interest in that property because that property could potentially be converted into cash which to pay your bill.
I got it.
So you see, you don't have to have a specific connect to the property, but if there's some logical thought process that leads to the conclusion that the property is going to serve your interest, then you have an interest in it. Okay, we have here, let's see, California Code, and we have the Code of Civil Procedure. Let's see if I can find this section for you so that.
It's not showing up on the screen.
Okay, I understand. Not a problem.
There we go. You got it now.
Okay. And see if this deals with money judgments. Okay, that's not it. Let's go to 881. This does. Well, it's in the 800 series, I believe. So, well, these are pretty big files. That's why I didn't do a search, for that very reason. But let's try, let's see, 873. That's what we can do if we have to. Let's try 80. Let's try 802.
On the counterclaim, did the car companies demur also?
Yes, the car companies also demurred. So, not it. Oh, well, I seem to have trouble with these things. Oh, well, let me do it the easy way then, now that I've tried the hard way. The easy way is just to go to the paper that we created. Okay? Okay. Okay, what's that? Count 25. Thank you. Appreciate that. Okay, we have in our paper here preservation, okay? And so these are the 4 different judges. So we'll go to that. Okay. Okay. Here's the actual, here's a form, I guess. Oh, there it is, 880.020. 880.020. Okay, and this form that you see here was taken out of that code. And then we filled in the appropriate blanks. Pardon? Yep, CCP. Okay, so now let's go back to, right, 880.020. So reference law books, California Code. I knew I was close. Okay. 880. That wasn't it. Okay, so this is, it might be out of place or something. That's not it. 880. That's it. I guess it's in there. All right. Just not sure where. Seems like it should be there in one of these two. Let's try this one. That's 881. This one says 880. I'm not finding it. See, this just goes to 880. So we're missing a section here off of this, apparently. Okay. Well, I guess I can't produce that one either. But anyway, you have the section number. All right. There it is. We got it out at 880.020. So you should find that very handy for putting liens on people's properties. I mean, for all practical purposes, that's what a preservation of interest is a lien.
Can you call it that in the body of your preservation?
I wouldn't. I would call it what they call it in the code, preservation of interest. You're preserving your interest, a very honorable thing to do, you know? So, okay, well, anyhow, okay, I guess we're at this stage on this thing. So counterclaimant was involuntarily brought before a court not of record and not an nisi prius court. Exhibit E contains a true and correct copy of the official record of the said court. And so we basically, the official record, what we do is we go to the court clerk and we get from the court clerk a certified copy of the docket sheet. Okay? Sometimes it's called a register of actions. But basically what it is, it's a list of all papers that have been filed and decisions that were made by the court, who was at the court, you know, show who the players were and this sort of thing. So you should always, whenever you have a question about something, you should always go to the court, get a certified copy. That way, if they try to go back and predate something, then you have the proof because it's certified. This is what it was on that date. Now, it always takes, in your bigger court systems, it always takes maybe as much as a week to get papers listed on there. You don't necessarily know if a paper got filed until a week later, okay? But you get to know the system that you're working in. In Los Angeles, I think it takes at least probably 3 days for things to show up on it. But nevertheless, you go down and check, and after whatever time is reasonable for that court system, you check and make sure that you know what's on there. Sometimes they will put papers in, claim they served you, but didn't. Okay, that's happened. Other times they will claim that they filed something on such and such a date when in fact they hadn't. It was like maybe a week later or something. So you have to guard yourself. A normal motion requires that you answer within 20 days, I think it is. So the logical thing to do is to go down and check the record every 10 days. If you really have a hot case going, make sure that if something shows up, that they didn't sneak it in on you. Because you see, the burden of proof is on you to prove that you did not receive it. Well, how do you do that? I mean, that's almost impossible to prove you did not get it. Okay? So you keep on top of your court case. You always know what's in that record. You should have a file that looks like their file, you know, that has everything, all the papers organized. Okay, so anyway, let's see. All right, Laura Ellison acted as tribunal and magistrate. Jody Michelle Link acted as a district attorney. Counterclaimant Aurora objected to the jurisdiction of the court and the appointment of Butko as her public defender. Counter-defendants Ellison, Link, and Butko, without proof of jurisdiction, each ignored Aurora's objections and proceeded under color of law to continue her imprisonment, this time for the stated purpose to declare, quote, a doubt as to the mental competence of the defendant. You see, when you have something going in court, if you make an objection, that would be noted on their record, okay? Even if their record is not officially a record, it's still going to be on there. Well, she objected. These things didn't show up on the record. And not only that, she supposedly has a public defender, and it said right in the record that the public defender, I think it was his motion that she be evaluated. Okay? So which team is he on? So anyway, that's why that public defender is being sued. Instead, the record shows that Butko joined in with Ellison and Link to deprive Aurora of her liberty and to continue her imprisonment. The proceeding and subsequent imprisonment is reminiscent of the cooperation between the KGB and courts of Russia against anyone who fell into the government's disfavor. Psychology was the tool used to confine Russian citizens for decades. On or about August 6, 2004, counterclaimant Aurora was involuntarily brought before court, not a record, also not in Nisi Priya's court. And Exhibit E contains a true and correct copy. And this is all repetitious. I mean, session after session, it was the same thing. So we can kind of skip down a little bit here, because it's really the same thing. It says, Eileen Butko did not defend counterclaimant Aurora. Further, a habeas corpus from the court of Aurora was summarily dishonored by Ellison. Ellison was the judge. Okay, and we go further down. Let's see how far we can go down here. Okay, second cause of action. The first one was trespass. This one's trespass on the case. No violence involved. Okay. Paragraphs 1 through 27 of the first cause of action are included by reference as though fully stated herein. A cause of action means that you have some cause, some reason for suing. In other words, the cause of action is the reason for the suit. So we have this lawsuit going, and we have a couple of reasons, and so we're now into the second reason. Now I want to tell you something. You have a cause of action. That's your basic. Here's the injury and the damages for it. But what is your legal theory? Well, your legal theory might be called a count. Okay, count 1, count 2, count 3, all within the same cause of action. But you might have different theories. So the courts have said that although you may have a cause of action, you might have two different counts that are conflicting in their theories. Okay? One may be totally opposite to the other for whatever reason. The Supreme Court has said that's okay. You know, you get them on whatever theory you can. So you do not have to have agreement. You lay out your count, and you say what you're going to say, and then when you're all finished, you come up with a new count, totally different theory of operation. On one, you could have the theory of sovereignty, and another, you could have theory that you're a citizen, if you chose, if you thought that was advantageous. Doesn't matter. They can conflict, and they have to be considered equally. Of course, if they conflict, ultimately only one will be ruled favorable, and the other will be ruled unfavorable. And you're doing the ruling, by the way. Okay? So, remember that this paper is being written by the plaintiff. So, sometimes you make claims which don't hold up under analysis. That's okay. You're the plaintiff. I mean, obviously, you want the highest quality you can get. But don't worry if you come up with some anomaly in your thinking. You're bound to do that. However, when the day comes when you're writing the judgment, you want to be absolutely down the middle of the road and absolutely precise on everything. Okay? It's a different point of view, a different attitude. You're almost like a different person. Okay? But anyhow, we saved ourselves some writing by saying that paragraphs 1 through 21 of the first cause of action are included by reference as though fully stated herein, because everything is the same, see? And you'll notice that there were 27 paragraphs above. So the last 6 paragraphs don't apply of the first cause of action, just the first 27. And then once we have that as a basis, we then write the rest of it. So she says, by right, counterclaimant reasonably expects to proceed without injury, secure in her capacities. By right, counterclaimant reasonably expects to exercise her right to negotiate and to enter into a contract. Counter-defendants have a legal duty to use due care and not cause an injury to plaintiff or interfere with said rights in any way. Again, we're talking about nonviolent type injuries. Counter-defendants breach that duty by proximately or legally, directly, and indirectly causing the injuries to plaintiff. Now, where am I getting these things? Well, basically, and the damages claimed are all a result of the injuries. So, third cause of action, trespass on the case, vicarious liability. Vicarious liability means that although the person was not actually there, that person had some connection and therefore is liable. Take, for example, the most obvious example would be driver's licenses. Okay? The state passes the laws, whatever the driving rules are. So the state, when it passes rules, but otherwise does not participate, then the state has immunity. Because all they're saying is, hey, everybody, here's how we think you should do things. But it's up to the people themselves to do or not do. And if there's a problem as a result of that, it's up to the people themselves to settle whatever it is, through lawsuit or negotiation or whatever. But the state's not involved. The state just made a set of rules. But that's not the case with the state now. The state, first of all, does quality control. Okay, they test you to see if they're going to issue the license. Then they have a quality control team out there called traffic cops. And they watch how you drive, and if you're not to their satisfaction, they then issue tickets. Then they have safety programs, and they have advertising, and they get involved with the process. So they lose their immunity. Okay? So because they have all this going, if a licensed driver has an accident, the state has part of the liability. If the driver's liable, then the state is liable. Because, why? Because they're involved in the process. They entered the commerce. They're participating in the commerce, so they have no they have no protection. If you look at the website, on the website, there's an example. You're all familiar with that. That example goes specifically into that issue. Okay? So it's real. All right. Here we have a little, anyway, vicarious liability means they weren't there, but they have a connection. So that liability comes through to them. And it's nice to throw in these little quotes, you know, from respected source. Power is never without responsibility, and when authority derives in part from the government's thumb on the scales, the exercise of that power by private persons becomes closely akin, in some respects, to its exercise by the government itself. So what we're saying is that you have a private person who is doing something but is under the influence of the government. Well, then that's an action by the government. So the government is liable. So that's vicarious liability again. The purpose of imposing vicarious liability is to ensure the costs of injuries resulting from defective actions are placed on the source of the actions and others who make the actions possible, rather than on injured persons who are powerless to protect themselves. That's how you hold the state responsible. For a counter-defendant to be vicariously liable, it must play an integral and vital part in the overall production and promotion activity so that the actor is in a position to affect others, or at the very least, it must provide a link in the chain of exposing the ultimate victim to the actor. The vicariously liable counter-defendant must be in the business of controlling, leasing, bailing, or licensing the actors. That little writing there, that writing is in Aurora's action. But I'll tell you something. Those words came directly out of a case involving vicarious liability. Okay? It's a quote without the quotes. Because basically later on, you've defined the problem here, and by the way, they did not object to it, so that means they agree. And then you find this case that says exactly word for word the same thing. You know, the theory on case law is that if your circumstance is similar to that circumstance, then whatever decision was made there should apply here. Well, we just copied word for word, a little adjustment, you know, we said counter-defendant instead of defendant, that kind of thing. But that's how you get the perfect match. Okay? We said each defendant is an agent of the other, and each has his place in the chain of exposing counter-plaintiff Aurora to the actors. Each counter-defendant is vicariously liable for each instance of injury to the counter-plaintiff. So you see, that's how we connected. If somebody's acting as an agent for someone else, this is how we connected them. Law of the case. Now, in your lawsuits and also in your motions, the general rule of thumb is you cannot submit more than 15 pages. So sometimes you get a big case, it's hard. Now, it doesn't mean you can't have more than 15 pages. But if you are going to run over 15 pages, then you should go back to the court and explain to the court that you need permission to have more pages because it is complicated, and you can get it. However, what we did is we limited it to 15 pages. As a matter of fact, well, we have 16 pages according to this. But the way we limited it was we made the law of the case an exhibit. There's no limit on exhibits. Okay? So we set up the exhibit and then incorporated it by reference. Okay? So right here, after the we have the counterclaim, and then we have the law of the case. Okay? This is Exhibit G right here. So, and it's labeled as such at the bottom. Okay? It says Exhibit G. And basically, we say the law of the case is decreed as follows. Again, you're in your sovereign capacity. And so, as a sovereign, one of the characteristics of sovereignty is that the sovereign decrees the law. You have no law until some sovereign steps forward and decrees it. So, Aurora is the sovereign, and so she says here, the law of the case is decreed as follows. It is the public policy of the state, and so on, so on, and so on. Okay? So, we got all these rules, and it turned out that we've got 6 pages of rules. Okay? And it's not even signed. Doesn't have to be signed. Okay? Why doesn't it have to be signed? Well, here's why. First of all, it's labeled as Exhibit G. Okay? Secondly, Exhibit G is incorporated by reference as though fully stated herein. So whatever Exhibit G is, if it had not been Exhibit G, it would have been written in here. And so we say it's incorporated by reference. In other words, we copied it in. So the signature at the end of this paper applies to the exhibit as well, because it's incorporated. That's why, yes.
So in other words, if you have a 100-page exhibit. In other words, if you have a 100-page exhibit, you can incorporate as stated herein without making your thing very large.
Right.
Okay.
Right. And that's an important writing technique. Got to remember, that these judges read thousands of papers every year. I mean, they do a lot of reading, okay? Assuming they do read them. And because they've been known not to read them too. But, I mean, it's understandable. They have to plow through this stuff. It's loaded with detail. So they tend to want to take shortcuts. So when you do your writing, you want to make it easy for them to read. So one technique to make things easy to read is to use subroutines, as computer programmers would say. And basically what you do is you incorporate by reference. You've got the big picture what this is. It's a law of the case. Now, if they want to read the law of the case, they go to the exhibit, and that's all law of the case. But they're not burdened with reading the whole thing as part of the main text. Yeah, so you're able to, like, in a sense, you know how it is with web pages. You look at a web page, you see something interesting, you click on it, you get more detail when it links over. Well, that's essentially the technique you're using. You say, well, Exhibit G is incorporated by reference as though fully stated herein. It's under the heading Law of the Case, so the person kind of knows what it's about. When he's ready, he'll go look at it. Otherwise, he can continue. So then we have the request for relief. For that cause of action, therefore, plaintiff brings her suit. Wherefore, counterclaimant requests relief. And you see, we probably should have said up here, we probably should have said counterplaintiff. That was a mistake. Okay? Minor mistake. Here's the beauty of this whole thing. You're the sovereign of the case, right? When you're making judgment, you can excuse the mistakes. Okay? I mean, everybody reads this. They know what you're trying to say. If somebody wants to read a technical point, what the court can do, that means you can make a ruling. And you can rule that this isn't to be interpreted a certain way. Plaintiff means Aurora. Counterplaintiff means Aurora too. Okay? Because from the context, you can tell who's who. You know, this is a counterclaim, and she's saying she's bringing her suit for that cause of action. Okay, so on all the causes of action, she wants $50,000 multiplied by the number of days in constructive and actual imprisonment. For loss of earnings according to proof, we'll never deal with that because she doesn't have a good record of what her earnings were. See? So there's no point. You can ask for many things. It doesn't mean you necessarily have to follow through on it. Okay? Part of a lawsuit is psychological warfare. You ask for things whether you deserve them or not. Okay? It doesn't mean that you're going to be casual about it. What I'm really saying is that sometimes you think you want to ask for something, and later on you decide, well, that really wasn't such a good idea after all. There's no damage done. Because when you make the ruling, you can say, not granted. Okay? You can deny yourself. We've done that. We've actually done that. Okay? Because why? Because you don't want to look stupid to the rest of the world. Okay? You're depending. These papers are your way of letting the rest of the world know why it is that your decision, whatever you made, is the correct one. And you remember, you're going to be sending the sheriff out to enforce that judgment if you can. Well, how far do you think if the sheriff thinks this is a stupid, senseless judgment? You know, I can just see it now because this has actually happened this way. The sheriff picks up the phone, calls the defendant, and says, I'm coming out there at 2 this afternoon. Are you going to be there? The guy says, yeah. So the sheriff goes out at 2, and he's not there. So he comes back and reports, you know, I went out to look, I couldn't find him. So he couldn't enforce the judgment. I mean, how do you make a sheriff collect if he doesn't want to? So you have to pay attention to your politics here. You've got to do what you can to impress these people that you're the underdog, that you're just looking for justice, you're not asking for more than what you deserve, you know, that kind of thing. Okay. One of the things asking for is that the court enter a declaratory judgment that counter-defendants have acted arbitrarily and capriciously, have abused their discretion, and have acted not in accordance with law but under color of law. Now, a declaratory judgment is a judgment that declares the status of the parties. All right? Now, in one sense, a declaratory judgment is actually an equity proceeding. In another sense, it's actually a common law proceeding. But the thing about a common law court is that although your primary lawsuit is common law, you can dip into equity. Okay? The main focus should be common law. The main purpose of the lawsuit should be common law. But, you know, an equity situation comes up, by all means, go for it, you know, if it seems like it applies.
Can you give an example?
Sure, I'll give you a perfect example. We have one actually called example. Okay, we'll go back to this. Okay, we'll go to the example. It's on the website. And we go down to the contempt ruling. This is where the court ruled that the judge was in contempt of court. And let's see. Whoops. There we go. Now, this okay. Here's what happened. The judge had issued an order, and we used a writ of error to vacate his order. So then, several months later, the judge forgot his lessons, and he issued another order. Well, the second time, he should have known better. So we found him in contempt of court. So the judge persistently wanted the California codes, and we're saying, no, we're not letting the California codes apply. But he was persistent about it, and that was the basis for his order, too. So when we found him in contempt of court, here's what we said. On more than one occasion, the magistrate has indicated his preference for California rules. And we have a note, okay? And we say, so be it for his cause. This court, for purposes of accommodating the accused's choice of law, adopts the California Code of Civil Procedure as it relates to contempt of court. Let there be no doubt as to the justice of this proceeding for the accused. And then we proceeded to hang him on his own choice of law, okay? Found him in contempt of court. So, well, you know, it was the sovereign that was writing this. The sovereign decrees a law, and the sovereign has the capacity to be flexible and rise to any challenges that come along. And this was one of those challenges. And this guy was so adamant about California codes, he wanted that to be law. Well, we gave him what he wished for. I believe there's a Chinese saying about that, isn't there? Be careful what you wish for, that it may be granted. Something like that. Okay, well, he got it granted. Okay. Let's see, what are we on here? So this is the law of the case. So we took all that law of the case and incorporated it by reference. By the way, on these papers, we have the lines numbered on the left side. Okay, lines 1 through 27 or 28. It's double spaced. Okay, that's what they like, and it's useful because when you're in court, you're talking about whatever's on the case. You can always say page so and so, line so and so, and it makes it easier for everybody. So you should have those line numbers on the left side of the page. They don't show here because of the way our method for creating this paper. But after we print it out, we then make a second pass, and we do print the line numbers. Okay. So plaintiff has asked for the amounts, loss of earnings, wants a declaratory judgment declaring the status of the parties. In this case, they want them to be classified as acting contrary to the constitutional right, power, or privilege, that they have acted contrary. We want a declaratory judgment that the counter defendant's actions were in excess of statutory jurisdiction, authority, and short of statutory right. So you see, the court of record can sit in judgment of anything, absolutely anything. When you're putting together your action, you say what it is you want, what you want the court to judge. Later on, the court will decide whether or not it wants to grant or deny whatever it is you're requesting. But there is no limit. And here, we're actually asking the court to make a decision as to whether or not these guys were in excess of the statutes. Okay? After all, it is a court of general jurisdiction. That means everything.
That even goes across Admiralty.
Microphone.
It even goes across Admiralty too, doesn't it? It goes across all the different jurisdictions.
Well, actually, well, yeah, it does. It could include Admiralty, sure. You could.
All of them.
Yeah, in a court of record, you could apply Admiralty rules, but understand this, that it is the decree of the sovereign that makes the law. So the court cannot pass judgment on a law that was not decreed. Okay? So you do want, you have to put together the law in advance. Remember this, that in a court of record, you put in everything when you file your lawsuit. You put in all your evidence, 100% of your evidence. Whatever you've got, you put it in right up front. You let the other side know this is what your evidence is. Remember, the two major parts of any lawsuit are facts and law. So the sovereign decrees the law, and the plaintiff puts in whatever facts there are, all the evidence. The beauty of that is that there's no discovery. Why isn't there any discovery? Discovery, by the way, is an equity proceeding. The reason there's no discovery is because there's nothing to be discovered. You put it all in. So we routinely ignore discovery requests. Now, under equity rules, yeah.
What if in a case where you need to go after like medical records or something like that to show further cause of damages, where they're not disclosing it, whatever, would you want to be able to put that in there so you leave that open for yourself?
Well, if that's your lawsuit's based upon those records, sure, you'd want to get them. And if they're not available, then get them under the discovery rules, because, frankly, they don't know the difference. Okay? These attorneys do not understand what common law is about. And they don't understand that there's no discovery in common law. But on the other hand, after having said that, I can tell you that there is some discovery, because if you know the evidence exists, you can get a court order bringing that out if they won't give it to you voluntarily. Okay? So in that sense, there is discovery. It's just not the equity kind of discovery. But you can definitely, you can pinpoint something. You say, I need this because that's where the evidence is. The court, you would probably grant your own motion. You know, of course, yeah, but don't, you know, in a way it kind of sounds funny that you grant your own motion, but the fact is that you can do this, but you don't want to be arbitrary about it or be unreasonable. You always hold short of what you could do, okay? Always hold short of what you could do, because you want to look like the underdog. You want to be a reasonable person who's looking for some fair degree of justice. You're not asking for too much. And that's the image you would like, you should project. Okay. That the court enter a declaratory judgment that the records of the court not of record are impeached for want of jurisdiction in the court or judicial officers, for collusion between the parties, and for fraud in the parties offering the record in respect to the proceedings. I'm not quite sure what, I'd have to reread the suit, but I think we found did we find something where they were altering the record or something like that? Oh, no, we had the collusion between the parties because the public defender was right there working with the prosecution to put her away. Tape change. Say anything you want, it won't be recorded. Yeah, I guess we have other recorders going too. Okay, so we also have, we're asked that the court grant the counterclaimant such other and further relief as the court deems proper. Now this is an interesting aspect of a court. You do not have to ask for anything, okay? The court can give it to you if it thinks you merit it, okay? A lot of people don't realize that, but that, there is no requirement that you ask for it. So you could put in, do we have a proctor in the house for the back row? You know what a proctor is? It's back in the old school days, you know, there was a guy sitting in back. He had this long stick with a little knob on the end, and he would reach through the crowd and tap somebody on the head if he was falling asleep. That's the proctor. So anyway, we've lost one. So anyhow, the court can grant. You know, if all the facts are there, all the law is there, the court can grant it anyway, even if you didn't ask for it. Okay, and then for interest as allowed by law, of course they're talking about statutory law. Usually in our common lawsuits, I mean, I put that in as boilerplate, okay? But the fact of the matter is that the amount involves so much that interest doesn't make any difference. No practical difference. You know, after you got $50,000 per day and the amount is now up around over $20 million, who cares about a few tens of thousands of dollars for interest?
Banks do.
Who? Banks? Are we banks?
Well, why can't we be as greedy as banks?
Well, you could. You could. But that brings up an important point. You know, when this common law, remember this, it's the policy to not acknowledge the common law. Okay? I mean, I've never seen the policy in writing, but I sure can tell it's there because of how they react to it. Look, if you're going to bring a case, this common law, this whole technology that I'm presenting to you is not one to be abused. Okay? You should be legally right, meaning according to statute, whatever it may be. You should be lawfully right, meaning according to the common law. And you should be morally right. Okay? Forget the written law. What about the moral values? You need to be right on all these accounts. And when you're right on all these accounts, it takes the steam out of the opposition. I mean, it's amazing what has happened. Yeah, I remember, I've told some of you about this. We had there was a case one time where this person had tried to file some kind of a paper, and the clerk refused to file it. This is in the United States District Court. I think it was in, I believe it was Idaho. Anyhow, she argued all morning. It was a Friday morning. And she argued all morning with the clerk. I mean, they spent about 4 hours going back and forth, and she had an order typed up ordering the clerk to file it, and the clerk wouldn't recognize any of it. And they were very friendly, by the way, because she had made certain that that they retained their friendship. You know, they had a good working relationship, but there was a definite difference of opinion. Okay? So she went away at noon, went back home, called me, you know, to see what ideas we could generate out of this. And then then But anyway, regardless of what our discussion was, the very next morning in the Saturday Mail came a letter from that clerk apologizing for not filing it and telling her to bring the papers down and she would file it. Because what had happened was that after she left at midday, the clerk went on and did the research, found the appropriate statute that said that she could file it. And so she did. Now, that person that did that research, I mean, she didn't really have to do that. I mean, that wasn't the normal job description, but she did. Okay, that was Section 1361, 1361 of Title 28, United States Code. 28 U.S.C. 1361. And what that section says is that the United States District Court shall have original jurisdiction in any action in the nature of mandamus requiring a public employee to perform a duty owed to the plaintiff. Now notice that. Duty owed to the plaintiff. Didn't say anything about the defendant. Why? I mean, normally these laws are written fairly neutrally. They apply to everyone. No, this only applied to the plaintiff. Okay, what was going on? Well, what was going on was that this is the plaintiff's court. The trial court is owned by the sovereign. The defendant is the subject of the sovereign. If there's a duty that's owed by the clerk of the court, remember, the clerk of the court works for the sovereign. The clerk of the court is in the sovereign's castle. You know, just imagine you're sitting in a castle on the throne. You know, you have all your personnel. That clerk doesn't owe any duty to the defendant, not in the sense that the defendant can walk up and demand it. Sure, the defendant can walk up and demand it, and the clerk can ignore him. So, but because the plaintiff owns the court, is the sovereign of the court, the plaintiff can initiate an original action ordering the clerk to do her job, to perform that duty that's owed to the plaintiff. Well, that makes sense. The king can order his own personnel around. But if the defendant wants anything, and he might be entitled to something, if the court personnel refuse to do it, he cannot issue a direct order like the plaintiff can. He has to go up to the appellate court and have the appellate court, which is the higher court, order the lower court to do the job. And that's how he gets his rights. Well, normally it's the defendant that's having the problem with the clerk. And so the clerk had a misconception about this and was insisting that the procedures followed by defendants had to be followed by the plaintiff. But once the plaintiff left, she did the research, found it, and said, oh yeah, district court has original jurisdiction where the plaintiff is involved. It's a very valuable find because the biggest thing about that particular rule was that it proved the theory that we'd had all along. From our research, we believed that the plaintiff was in charge, but this was the first actual biased evidence that we found in favor of the plaintiff. Got a question coming up here.
Yeah, I wanted to know if you know of any similar statute in California regarding county recorders recording common law documents.
Well, that's a good question, and I don't have an immediate answer, but I have a speculation. And my speculation is this, that it's your court, okay? You handle your court. Just imagine you're a king on a throne in your own castle. And so you set the rules, you decree what laws apply, and of course you try to look very reasonable, but that's what you do. And then once you arrive at a judgment, then the next step would be to have the clerk certify the judgment, okay? And you take that over to the county recorder, and the county recorder, if the judgment involves property, real estate, then the county recorder will record it. And that seems to be okay, but you have to get that clerk certification.
The last time I tried that and was denied, they gave me a sheet. They referred to some statute that said that things that recorded had to be approved by a court of competent jurisdiction. So
that's right.
I just have to go in competently with my jurisdiction as my own court.
Well, yeah, you see, a court of competent jurisdiction, that just means a court that has jurisdiction.
Right.
Not all courts have jurisdiction on all issues. Certainly an admiralty court has no common law jurisdiction. An admiralty court has no equity jurisdiction. It just has the maritime or admiralty jurisdiction, and that's it.